here. That's right. We've got. Thank you. Morena, welcome everyone to this fifth and final day of hearings in relation to matters of interest for Omokoroa. Just before we get underway and make introductions and open the hearing, I'd just like to ask Ms. Bennett to lead us with a karakia.
Rua o mātou harami mātou hoki e muru nei o te hunga e harana kia mātou. Au hoki mātou I kawe kia whakawaia ingari whakaorangia mātou I te kino nāu hoki te rangatiratanga, te kaha mai, te kōria ake ake. Amene.
Amene. Kia ora. So look, we're now opening the hearing for the notice of requirement for the active reserve in Omokoroa, and in the meantime, we've adjourned the hearing for the broader issues for Plan Change 92. We're going to come back to those later today, so that everyone knows that that's the process we're running through. We're all looking forward to running to the wire at 5 o'clock tonight. Look, and since we've got a new team here today, I think it's useful to go around and make a round of introductions. So if we start with our commissioners, and then we're going to come to this side of the table and then to the staff team, if that's all right. We'll start at your end.
Yeah, for those that don't know me, I am Alan Withy. I live at Papamoa Beach, and I've lived in the Bay of Plenty since 40 years. And know the area well, but to the best of my knowledge, have no conflicts of interest in the proceedings today.
Complete opposite to Alan. I'm a city girl. I live in Tamaki Makaurau, and I do not know Western Bay of Plenty particularly well, but I have gotten to know it a lot better over the last week. Thank you.
Tēnā tātou I te whare, ko Pia tōku ingoa. My name is Pia. I'm from Tauranga, born and raised, and in a previous life practitioner in the RMA space, mainly for iwi and hapu. Kia ora.
And my name is Greg Carlisle, and I'm an independent planning consultant, and I come from a small town called Martin, and the issues that you're addressing here are not the sorts of things we have going on in our part of the world, but I've spent a fair bit of this last few years in the Bay of Plenty on various cases. So I've got a much better understanding of this issue than I had a week ago, and just to let the team that's here know, we did a site visit earlier this week. So we've seen the site and we've put it in the context of Omokoroa more generally. So I'm looking forward to hearing the contributions from everyone today in that regard. So perhaps let's start with a round of introductions on this side of the table, so everyone knows what the role and contribution is going to be.
Morena, my name is Horowai. I'm the Governance Systems Advisor.
And I'm Rosa. I'm the Governance Advisor, just helping out.
Morena koutou, ko Natasha Ryburn Tokowinga. I'm the Environmental Consents Manager here at Western Bay District Council. It's been in the Bay 1 year, previously at Waikato, so yeah, thank you. And I'm here to support James Danby, our reporting planner for the, kia ora.
Tēnā koutou katoa, Atamarie Commissioners, ko James Danby tēnei. I'm the reporting planner on behalf of the council.
And look, we'll just go into the back row so we're all familiar with one another, if that's all right. Perhaps start at your end.
Good morning, Aaron Colley on the backup. I'm just here listening.
Yes, thank you very much and welcome back. Kia ora. Thank you. Thank you, and thank you to those who are making the time today to appear in front of us. So let's go to this side of the table. We'll start at this end.
Kia ora tātou, ko Gemma Hollis toku ingoa. I am here with the requiring authority as legal counsel.
Thank you.
Morena koutou. My name is Kate Stubbing, also here acting for Western Bay as requiring authority.
Morena, I'm Jeff Hickstall. I'm a planning consultant here supporting the Western Bay's case for the notice of requirement.
Kia ora koutou, ko Jeff Canham, tuku iwa. Ko te rangirehu te puna aho. I'm a Parks and Recreation Specialist and APRO accredited. Kia ora.
Good morning. My name is Annelie Beidenhorst, and I will be assisting with presenting some of the evidence relating to the acquisition of the Inawa land.
Thank you.
Morena koutou, ko Peter Watson tuku ingoa, ko whakahari whenua Rahui, Reserves and Facilities Manager here at Western Bay Planning District Council. I've been in this role for 22 and a half years now, and been in the local government industry parks industry since 1981, and a fellow of Recreation Aotearoa.
Morena koutou, I'm Natalie Rutland. I'm the Environmental Planning Manager here at Western Bay Planning District Council, and work with the team that's overseeing the plan change 92 process, and involved in that with the notice of requirement also.
Thank you.
Morena koutou, I'm Georgina Dean, Acting Hearings Manager and Senior Urban Designer for the Environmental Planning team.
Oh, thank you very much. So for those who don't spend a lot of time in these hearings, I'm assuming that this isn't a hobby, it's important to you. Just to explain how the day is going to work, we are going to hear from the council, and they're going to effectively advance their case for this notice of requirement. We're then going to hear from submitters, and then the council has a right of reply to close out. We're four of us, obviously, we're independent commissioners, so we're not employees of council, not involved in any way. We'll then make our decision, and the current plan for that recommendation and decisions set to come to council is November this year. So that's the kind of timing that we are working to at the present time. So on that basis, I'd like to invite the council to open its case, and I'm assuming you're starting with legal submissions.
Yes,
Thank you.
That's right. I thought it might be useful just to take a moment as a bit of a reset following the Plan Change 92 hearings we've had this week. So today we're obviously dealing with a notice of requirement, an application for a designation. So the key provisions is section 168A of the Resource Management Act. You'll probably be pleased to hear that the case law on these matters is fairly well settled. There's no Amendment Act that has intervened and brought in a whole raft of new considerations. And just in terms of the documents before you today, I've got them in two fairly small blue folders, so it's much more discreet than Plan Change 92. We've obviously got the original application document, the reporting planners, section 42A report, three statements of written evidence on behalf of the requiring authority, just noting that Mr. Watson, the Reserves and Facilities Manager, was overseas when the evidence was prepared.
So does not have a written statement, but I would ask him, with your agreement, to provide some comments today. And then we have written statements from Mr. Taylor and legal submissions from TDD Limited, and then a brief reply from Mr. Danby as well. So I'm not sure whether the panel has had the opportunity to read all the documents. I'm getting some nods. So in terms of the legal submissions, I think I'll just speak to some of the key points. Obviously, the urbanisation and the growth of Makaroa is now fairly familiar to the panel. But we're here today, the council is seeking a designation for the future establishment of an active reserve on the site on the corner of Makaroa Road and Prole Road to provide for a number of activities: playing fields and associated structures, club rooms and changing facilities, playgrounds, indoor sports centre, aquatic centre, parking and associated connections. The Stage 3 planning process, which you've heard a lot about this week, identified the need for a large active reserve as part of the urbanisation and expansion of Makaroa. Quality planning of new urban areas involves more than just providing land and infrastructure for housing. You've heard this week the smart growth principle of live, learn, work and play. By enabling the development of an active reserve to host sports and recreation activities, this notice of requirement seeks to support existing and future urban growth in Makaroa as well as the wider Western Bay sub-region. At paragraph 5 of my submissions, it states that the issue for the commissioners is to determine whether the council has satisfied the requirements in section 168A, such that the designation can be confirmed subject to the proposed conditions. On the second page of the legal submissions, it covers the submissions received following public notification of the notice of requirement. There were 6 submissions received. 2 of those were in support, one from the Makaroa Country Club, and the second was a conditional support from Heritage New Zealand, who through a letter tabled with the evidence has requested a condition which is supported by the requiring authority and shown as condition 6 of the latest version of the draft conditions, which I do have a hard copy of, and I wonder if it would be an appropriate time to hand those up.
You're talking about the conditions themselves?
Conditions,
Yeah.
yes, they were.
I'll try and circulate them.
Yeah.
I think some of us might have them, but.
This is the version attached to Mr. Danby's reply statement.
Yeah.
And these are supported by the requiring authority, so there's no issue in terms of conditions between requiring authority and the reporting council team. There were 4 submissions in opposition to the notice of requirement, and obviously we have 3 of those submitters here today. The issues raised in those submissions relate to concerns about the continuation of the existing land uses, and concerns regarding the loss of property, businesses, matters relating to the land acquisition process, and whether all the land within the notice of requirement is required for reserve purposes. One submitter at paragraph 10, I understand, is no longer appearing today, raised a number of matters which, as you'll see in paragraph 10, I say are irrelevant to the notice of requirement process. And I will turn and address the concerns from submitters as we move through the submissions. The statutory considerations, as I've said, are set out in section 168A of the Resource Management Act. And the question for the panel is whether, having regard to those matters, the requirement can be confirmed, modified, or not confirmed. And unlike Plan Change 92, where the panel is making recommendations to the council, your role on the notice of requirement is to make that decision. And noting that the usual rights of appeal to the Environment Court apply here, there's nothing streamlined or fast-tracked about the notice of requirement process. I've set out at paragraph 16 the matters the panel is to have particular regard to, and I will touch on those and then go through each of them in the submissions that follow. The first one is the relevant planning instruments. B, whether adequate consideration has been given to alternative sites, routes or methods of undertaking the work. C, whether the work and designation are reasonably necessary for achieving the objectives of the requiring authority for which the designation is sought, and any other matter the panel considers reasonably necessary. In my submission, these are not tests that must be met, but they are matters to have regard to when considering the effects on the environment of allowing the requirement. Turning to the first matter, whether the designation is reasonably necessary for achieving the objectives of the public work for which the designation is sought. In his written evidence, Mr. Hextall has described the designation as reasonably necessary to create an active reserve to provide for the social and cultural well-being of the current and future occupants of Mokoroa. In his written evidence, and he'll discuss further today, Mr. Canham has described the shortfall of active reserve land within the Western Bay sub-region and confirms that the active reserve is required to cater for the future population as well as the wider sub-bay area. TDT Limited has questioned the requirement for the size of the land within the notice of requirement. And in the legal submissions for DDD, there's a suggestion that the wider network of walkways and reserves may provide cater for some of that need, and to some extent suggests that the school sites will also provide some of that reserve. So that will be addressed by Mr. Canham today, discuss the nature of an active reserve, and talk to some examples where it's actually schools who use public active reserve land rather than the other way around. You will have seen the indicative master plan, which is in concept form at the moment, but shows the site is capable of accommodating the activities listed in paragraph 3 of the submissions, which are also set out in condition 1 of the proposed conditions. In my submission, the full extent of the site is reasonably necessary and the most appropriate means to achieve the council's objectives. And I note there that the reporting planner agrees with this conclusion. Turning to the consideration of alternatives, there has been a comprehensive assessment of alternatives through the structure plan process, which you have heard about this week. And that process also involved public consultation on the 2 preferred options. As you will hear from the evidence, the location for the active reserve needs to be centrally located, highly accessible, linked to the wider reserve network, geotechnically stable, relatively level, and the site before you was chosen as most suitable for the active reserve. In the documents, it talks about being the superior option from a placemaking perspective, and the witnesses can speak to that further. Just noting, when considering the adequacy of an assessment of alternatives, the question is whether the requiring authority the investigation was sufficient to satisfy itself of the alternatives and that it's not acted arbitrarily in its alternatives assessment. Both Mr. Hextall and the reporting planner agree that there has been adequate consideration of alternatives in this case. I have one paragraph, paragraph 29, on the relevant planning instruments. Again, just noting that both Mr. Hextall and the reporting planner agree that the notice of requirement is consistent with those planning documents, and I don't think I need to take that any further. Turning to effects on the environment. The effects have been assessed in the original application, the Section 42A report, and through the evidence. So I will go through these briefly. There's been consideration of noise effects, but these are not expected to be unreasonable or out of character with the surrounding land uses. In terms of traffic effects, to some extent, the effects of the notice of requirement in terms of potential traffic effects have been addressed through the structure planning, which, as you know, is proposing to urbanise the land that has been identified as future urban for some time. So matters such as traffic can be appropriately addressed have been appropriately addressed through that process. The new buildings and earthworks on the active reserve may have some impact from a visual perspective, but in my submissions this can be addressed through the final comprehensive landscape design once the site layout is finalised. In submissions for TDD Limited, there's a suggestion that there may be effects of having the active reserve located close to the industrial zone. Mr. Hextall will speak to that this morning. At paragraph 35, noting that the peninsula is of high cultural significance to Tangata Whenua, there are no submissions on the notice of requirement, but the requiring authority will continue to work in collaboration with Tangata Whenua in developing its plan for the active reserve, and Mr. Watson can speak more to that process this morning. I then turn to the issues raised by the submitters in terms of effects on their existing land uses, the uncertainty, the viability of their business operations, and the social and economic effects on those landowners. And I would like to acknowledge those concerns and that processes such as notices of requirement and designations do create uncertainty. We've heard from submitters on Plan Change 92 on similar issues this week. We provided written evidence from Ms. Badenhurst, and we have Mr. Watson here today to provide context and more information on the council's pre-acquisition process and provide some more comment in terms of timeframes to hopefully provide some greater certainty to those submitters and respond to the concerns around the potential sterilisation of the land for over the period of the notice of requirement. What I address at paragraphs 37 and 38 is some of the case law on these issues. And in my submission, the approach the court takes is weighing the necessity of a designation against these matters. At paragraph 38, and I've referred to an Environment Court decision from Auckland relating to where the council was seeking to designate parkland within Mount Wellington. The landowner appealed that process and had a resource consent for a retirement village on the land. I'd just like to read from that decision because I think this quote summarises the matter as it is before you. The court says it records its finding that the community's social, economic and cultural well-being and health would be better served by the sports field complex council proposes than by providing accommodation on the subject site for 242 retired persons. It goes on, the sports field complex will serve a significantly greater number of persons in the community, acknowledging that it's not a numbers game. We do not overlook the impact on the social and economic well-being on the consent holder in making this finding, but accept that such effects are amenable to compensation through the land purchase process. Acknowledge in paragraph 13 that existing businesses within the site do provide community benefit, particularly in terms of the childcare operation. But in my submission, based on the case law, greater weight should be placed on the wider benefit to the community arising from the provision of the active reserve facilities. The Public Works Act is intended to be a regime that provides for fair compensation for affected landowners and business owners, and I address that further below. Finally, paragraph 40 touches on the significant positive effects. These will be demonstrated through evidence. This will be key community infrastructure to enable the community to provide for their social well-being and health in an appropriate location to serve an area that's been identified for significant residential population growth. In terms of part 2, the notice of requirement will enable the social, cultural, economic and health and safety needs of people, community and future generations to be met through the provision of public active open space. I have touched on matters I say are irrelevant to this Resource Management Act process, and that is matters related to the land acquisition process. But as I've said, I've got 2 witnesses here who can speak to that further to hopefully provide some level of comfort to the submitters and the panel around that process. I've noted in paragraphs 46 and 47 that there's agreement between the requiring authority and reporting team in terms of the conditions. You have a copy of those before you. And so just in conclusion, in my submission, the NOR is reasonably necessary to enable the development of the active reserve to support urbanisation of Aotearoa and address the reserve shortfall for community needs. As you'll be aware, the requiring authority seeks confirmation by the panel of the notice of requirement on appropriate conditions. So I will now ask Mr. Cannon, unless the panel has any questions.
I've got a couple of queries. We'll just check with the rest of the team if there's anything else. Perhaps these are more observations and another one of the witnesses might pick up on these matters. It just follows the discussion we've been having over this last few days. I want to get clear in my head that when council is talking compensation, if it's talking compensation with the parties identified in the property ownership site diagram we've been given, will it be doing that in the context of the Plan Change 92 outcomes? So will those discussions be occurring on the basis that it's medium density housing, which is the underlying zoning for those sites?
Yes, that will be the implication of the Plan Change 92 decisions being confirmed.
Right.
It will be that medium density residential zoning.
Thank you. That's probably clear to everyone else, but that's useful for me to understand that. And then as the day progresses, I'm really interested in hearing from council and submitters further on what council says submitters think versus what the submitters themselves say, because those things are at odds when I read through the documentation. And today, for me, is really going to be helpful to provide some clarity in that space.
Thank you. We'll cover both of those.
Thank you very much.
Mr. Canham.
Kia ora koutou. I will just add a bit more to an introduction from a technical background perspective, because I think it would be helpful. I've had a 40-year career in parks, but it did start in technical turf, so I did have to start somewhere. So sports fields are something that I know from that end as well. I've worked for 5 councils in New Zealand. One of the ones here is Tauranga City Council. So I worked there for 8 years as the Parks and Leisure Manager. And in that council, I had exposure to the very modelling and reports that we're relying on today. That model has been running for about 25 years, excuse me, and that's one that has certainly been tried and tested. So that's to inform the commissioners, that's really the basis of evidence that's been used for some time, and it's been played out quite well in other projects around need and demand. I'm a former resident of Amokoroa, and I'm familiar with the sports fields in Amokoroa from a voluntary perspective as a coach. And I have provided evidence through Tauranga City Council's Plan Change 25 on the very same issue of sports fields need, TCC. Scope of evidence is where I provide information that's drawn from primarily those 2 reports. There's a summer and a winter sports field active reserve demand report that's commissioned by the councils. Refreshingly, it's based on demand as opposed to areas of land. Significantly, that most of the country does things along the lines of hectares per 1,000 of people and tries to sort of strike a balance between land area and people. Here, it's different. It's based on need through a demand model. I've documented the evidence that I've relied on, and there is a concept plan which I'd like to take you through as well, which identifies an overview of the reserve. The summary of my evidence is that when considering the future growth, there is a current shortfall of active reserve availability, and that is linked to a region-wide provision, which is the way it works around here between TCC and Western Bay. There is also the need to reflect that parks must be set aside ahead of development. If we have to rely on the sort of evidence where there's a crisis, we've already lost the opportunity to get the land. And that's a principle, fundamental of providing parks. The active reserve plays a strategic role for the future. And now we know what it's for, but in the future it might be for something else, but we need to provide it. I'm moving quite quickly through to the supply and demand considerations, and I've touched on the sports field reports that we're relying on. But maybe first we look at the concept. Primarily an active reserve is a place where, if you like, sports is played. It relies on a field configuration for the most part and a variety of surfaces, and it provides for winter and summer codes. These days, and specifically for Western Bay Tauranga, they rely on what's called a sportville or a sports hub model. So it's a conglomeration of clubs. It prevents duplication. It means that it's far more economic when capital's involved. Got a pointer. Nearly a pointer. Broken already. Should be that one. Should have bought the diesel one.
Should have bought the diesel. What done wrong? What have we done?
Fabulous. Red button. Here we go. There's a red button. Brilliant. So what we're showing is a reserve in a corner, which is a great place to put a park. Natural surveillance is huge for public parks, and we're following crime prevention through environmental design as a key principle, so that the visibility into the park from the surrounds is about people's welfare and the monarchy of visitors. Back to the configuration of the reserve, we've principally got, even within a 10-hectare site, 3 main field areas that allows for the summer cricket wicket oval as well. That's an immediate demand given that cricket, even though it tries to be played in Amokoroa, doesn't have a home right now, and that's an immediate deficit. In terms of these other facilities, the main one is about, main demand is about fields and availability of grass. particularly the junior fields, which is the most pressure being experienced at Western Avenue. And in time, we've got the ability for other things to occur. So the Mokoroa Bowling Club needs to relocate, and we've identified this location as their next home. They need to relocate because their current park is right next to the harbour and has an eroding bank. They don't even get to see the harbour because the trees they rely on for erosion protection are also putting roots under their greens, and that bank is well known to be eroding and falling into the foreshore. And we've also got the provision for hard courts, per our requirements, sufficient car parking, a community building indicated as a future indoor space for indoor recreation, and a club building as well. The connection with the school is something which I do speak to a lot, and right across the road where this reserve was originally going to be and once designated, that is now the school designation. On a corner provides for a number of other attributes in terms of not just active recreation. So we've got a peripheral trail, we've got the ability for people to use this park when they're not playing organised sport, and it still fulfills the needs as an open space. So whether that's kite flying and all those other things people use large parks for. Down the road at Western Avenue, during the day it is most busy for the playground side of things, and we show this play at the back of the reserve, if you like, towards the west, into the gully system, which it also connects with in terms of the trail system throughout the gully network of Mokoroa. And Tangata Whenua have already worked with Council on the theming, species and significance of the greenways throughout Mokoroa, and this provides a connection to that. The capacity of the site is significant. We generally need that space to provide for critical mass. In that way, we can conglomerate clubs and prevent duplication at other locations, and we can provide for something close to where people will enter Mokoroa from other areas to be part of a competition of sport, visiting teams per se. In the supply and demand considerations, there's a variety of things which I won't read them verbatim, but community need is something that we do have a really good understanding of. We do know the requirement for fields, and we do know what the deficits are now and into the future, and they exist. Servicing the schools is an important part of this active reserve. It will perform the role as other park areas do, but in a better way, as the schools expand. And as the school across the road, this primarily will be their green space, as we've learned, and I'll talk more to that. Talk to the bowling club, and I'm over at K and L. I think the regular field dimensions is something that I'll just come back to with the concept. What we've shown is the maximum field dimension for, say, a rugby, and that's sort of the largest, but primarily we'll be looking at football, soccer, and then the artificial number 17 shown does have a relationship with other such facilities in town, but this is more a projected concept. I stress that it's not a design. So we've not had a specific community process. There's no thresholds necessarily set for which sport might have an extra field and one might have less. That work is to come. In terms of the current supply, Bay of Plenty Tauranga, Western Bay, is probably one of the best in the country in terms of knowing what they need. As I say, going back to the Judy Longdill reports of the mid-90s, which I've been using since that time, another company has picked that up and effectively is following the same mathematical model, and there is a reliance on a mathematical model. In terms of those reports, I would add that there's a strong technical dimension which is mentioned in those reports, but we have other things in play. So we know already that an average sports field like the one on that concept is really only used for about 20 hours a week. So of that 20 hours, probably 12 hours of training and maybe 8 of play. And that's to grasp about what you get out of it. Already at Western Ave, we're seeing that's being exceeded, and at times that's led to some really significant issues for sport in terms of the surface they're on, maintenance costs to try and keep it playable for sport, but also capacity for lit fields in particular, that is for training. That current supply here is showing more training lights, and that's an immediate need, as is the cricket. So overall, The reports for winter and summer need lists in their appendices the tools available to council to deal with undersupply and oversupply. One of the key notes for options to address the shortfall is expanding the supply of fields, and that is the requirement for a Mokoroa, in my opinion. In a Mokoroa, there are deficits for the provision of lit hours, so that's for training. So at the moment, our evidence shows that training after hours, that is after 6, is running at a deficit. But more so in my experience, the junior codes are actually using the floodlights as well on additional nights after 6 p.m. And that means that Western Ave is already beyond capacity in that respect for lit fields. That deficit leads to an unavailability of training opportunity, and for junior codes that does imply a bigger issue around travel. Overall, between Tauranga and Western Bay, there are some areas of that sub-region, that show a surplus of fields like Papamoa, but in reality, juniors from Mokoroa are probably not going to drive to Papamoa for training. That is if they could get access to lights. The provision of training fields and lighting across the sub-region is an issue right across. And in my evidence, I've shown some rather boring mathematical tables around when those thresholds will be met. And that's driving a lot of the planning around capacity. When considering that overall catchment, there is some very good evidence around the situation that a Mokoroa will find itself in even with a brand new sports field. TCC for some years has not met its own requirements for providing that overall network, and the two councils work in tandem. In the mid-90s, I was responsible for acquiring brand new reserves in the west of Tauranga to prevent the very issues that are coming. And Tauranga City has chosen pre-commissioners to take a different route for the future of that land, vis-a-vis Parral Farms not being developed as an active reserve to meet the needs of this part of Western Bay to the west. Also, Smith's Farm was acquired for the purposes of an active reserve. That is not happening. And then in my evidence, I've documented the overall network impact of the Wairiki Active Reserve designation being removed by TCC and the sorts of deficit levels that's involving the whole region and by result of where people live having to travel further to get to parks to play their active sport.
Sorry, what are the drivers for those decisions to move away from utilising them for that purpose?
For TCC's decisions? Well, for Plan Change 25, they were blatant in that they felt that the land was better used for housing, and they went against their own policy to provide sports fields, and that was their rationale, and their legal opinion said they could. They also felt that people who were going to play in Wairiki could travel further to Te Puke and rely on Western Bay fields, and for developments that haven't occurred yet. So in the meantime, vis-a-vis to Timu, in the meantime, that pressure is coming onto Western Bay. Yes, very much. So with that in mind, there's also two pieces of evidence that the demand studies rely on as well, and that's the preparedness to travel. And there's some good research from Auckland around that. We know that there's a barrier to recreation around something more than a 10-minute journey in a car to take the kids to training. And we know that 45 minutes is a real killer in terms of people even going through with competition draw sport. If we were required to go to Papamoa, where there is a bit of a surplus of fields, we'd be doing that with everyone else in Tauranga, trying to book that time. And then the 45-minute journey is in play as well. Tauranga's traditional most busy traffic time is a Saturday morning, during Saturday morning sport. So it's already a highly mobile environment. To let people in a Mokoroa in the future, when a Mokoroa grows, rely on a Mokoroa reserve, and the people in the Kaimai area to focus on a reserve where they can go, definitely makes that more of a recreation opportunity that will occur. In terms of the consultation with the Ministry of Education, that has been an ongoing discussion. I'd like to add that I also have another role. I peer review school developments for Sport New Zealand as their representative, and I've worked with the new school context of the Ministry. The Ministry is very clear that new schools are not to provide for public recreation facilities. That's not in their brief. It's not in their funding model. They are not going to provide that. So we do that dance with every project. And they have a very high reliance on the council to provide land. Even if they do find their way clear to help fund that, they might say they will, but the Crown is quick to leave the room. So new schools typically, and especially in this area, have a high reliance, as the network does, on public land. So for example, schools, what's the most recent new one I can think of and was involved with? Gordon Spratt, the Papamoa High School. Throughout the development phase of that school, they continue to detune the green space in their development, relying on Gordon Spratt Reserve next door to provide all their open space needs. And then built the school, and then towards that building phase, entered into a community share agreement with the council to provide for their open space demand. So effectively subsidised by the ratepayer almost exclusively. Macville Park, next to Mount College. Mount College continue to build all over their green space and simply rely on Macville to provide their outdoor space. And there's a long list. In Te Puke, the Ministry have actually leased land from council to provide for hard courts and fields. And it is now pretty much an unspoken methodology by the Ministry when building a new school to target existing or new council parks to provide their open space needs. That is something that I have personally been involved with those particular projects, but all the way up to Wellington, and in fact questions of the Minister as to around the equity of that approach. In the case here, we've got a school across the road, and I think they will see the active reserve across the road and under the underpass from them as being a very key requirement for their school, rightly or wrongly, but the school will be a primary user of that open space for active recreation. Overall, there's another dynamic with TCC being the big neighbour next door. They're completely reliant also on fields that are affected by climate change. So that network is going to falter around Ferguson Park in Otamotai. If that hadn't had $1 million worth of drainage to address the water table, that park would be lost to us by now, and that provides for soccer, which this park would primarily also provide for football. TCC rely on a number of marae fields. They have for many decades actually, but not paid for it. And only recently, since the commissioners have come on board, has there been a contribution to marae fields. Again, the network is reasonably tenuous around those agreements, community share agreements with schools and marae. They're allowed to say no. The marae fields rely on a lot of tolerance from tangata whenua, in that those fields don't provide for great public toilets or changing, and sometimes they're simply not available during tangi. And schools, despite what they say when they want the money, often don't make available the open space once the capital investment's been received. So there's a track record of those community share agreements rescinding and being questioned pretty early on in the relationship. Again, my point is that council fields are really relied on as the fallback position for all of that. TCC have not progressed with around 80 hectares of active reserve that they should have brought on stream by now to provide for the future. And they're reliant on Te Timu to happen in Papamoa East to address some of that, but more so it's Western Bay. And I have worked at a strategic level with TCC, who have been very open in those sessions to say they're relying on Western Bay now for active reserves for the future, but it's a partnership. In terms of positive effects, I'm a parks person. I can talk all day about positive effects of reserves, but particularly entering an area of growth from Mokoroa, that profile of green space and the need for green infrastructure to also be part of a plan change and for a new environment with density is critical. Worldwide, more people are living in urban areas. New Zealand actually nearly breaks the record for how many of us are living in urban areas compared to the rest of the world at 87%. But that makes our requirement for parks far more significant to provide for the future. And we must lock in these locations of about this size to provide for way beyond our time. And it's the same rationale as Hagley Park. If they didn't provide that at an early stage, It doesn't really matter what it's going to be used for in 100 years, it just has to be in place. The location, though, is brilliant. In terms of an entry to a Mokoroa, that profile of a street corner to ameliorate the density, its linkage with what the Hapu are visioning as an extensive network of greenways, the focus that people are putting on trails and walkways to connect with large reserves, and the fact that it's part of a network at that location centrally and close to the state highway is a critical park attribute. In terms of the background for selecting that site, I've appended Council's quite good assessment of sites, and they focus on a number of those around that area. To pick up on the high points and the difference between some of those, the bottom line is that 10 hectare site that you see on the screen is centrally located and it's more accessible than the rest. It's got a higher profile and better sight lines throughout. It does exhibit the sort of contour, generally flat, that you want, and it's linked and more accessible to the school than the others. The park and ride situation is something I can support. And I think being close to a town centre, along with that connection to the school site, deals better with the reality of life. For caregivers ferrying children around, getting to sport, getting to school, picking up things. It's also my evidence that I think in terms of the modal movement and the modal shift, a centrally located park is perfect for people to go about their lives, have nature where you live, and actually save some car journeys. As a former resident of Mokoroa, there's an awful lot of trips to town when you've got kids doing sport, and that live, work, play thing is very important to prevent those very car journeys. I might dwell there because I've gone for it pretty hard, but I think in terms of a comparable size and best practice, Western Bay have done the work. The evidence is there in terms of the demand and modelling. There's some subtleties around the hours and some of the specific times when that comes in. But in terms of bowls, cricket and winter training, those things are upon us now. In terms of future fields and facilities at this park, Council needs the ability to be able to plan and raise money through the LTP and do the design work to fill in those spaces specific to people. There is a remaining discussion with Tangata Whenua around design, naming, co-design, co-management, all those things that will go across the whole network with the Mokoroa, and Piri-Rakau have made those points clear, and frankly it's the way we do things around here. So there's been co-decision making on reserve development in my own experience since 2006 with Piri-Rakau, and that's been way ahead of the general curve. I'll pause there, I think.
Thank you very much. That's very useful evidence. Can I ask commissioners whether there are any questions?
Thank you. That was a very instructive, big picture view of recreation and sport for the Western Bay. And I'm interested if you could just expand on that a little bit, the sub-regional, if you like, function of this facility. As a resident of Papamoa, I can well resonate with your comments about the time and the distance socially between Aomokoroa and Papamoa. But I'm just wondering how far north this will function, not necessarily in the short term, but in the longer term, you know, Waihi Beach, Waihi, even Paeroa, rather than Tipuki, Papamoa, Paengaroa, etc. You've obviously been around a long time and you thought about these issues a lot. Can you just give us a bit of an exposition?
Thanks, Alan. So in terms of the competition, so if you look at something like cricket, cricket goes into the Hauraki district in the Waikato and as far as far east as Whakatane in the junior to older student grades. So cricket seems to have more of a preparedness to travel. The issue with something like our bigger codes like football for junior soccer, the competition does take, say, someone from Mokoroa all the way into Waihi. But when I was amongst the Mokoroa Club, we would frequently have a bye in one of our games if we had to go to Papamoa because of the parents saying it was too far to go. And we did miss games based on a 1-hour trip at a key time. I think the benefit of the new reserve is probably reaching north or west. Waihi Beach has basically no provision, and people from Waihi Beach do rely on Katikati and the excellent Moore Park. I think between Moore Park and this new reserve in Amakoroa and being supported by Western Ave, that's going to take care of a lot of growth in that part of the Western Bay and pressure. In terms of Katikati, I don't think it would draw people outside of the competition to Amakoroa, but in terms of the Kaimai statistics that wrap around Amakoroa, that's pretty much the nexus for recreation. So people, in effect, drive down the hills from Wakamarama, Wright Road, even Minden. They need to make the choice from Te Puna, whether they go to Amakoroa or into town, but it's the same competition. And what we've seen with the competition is that it's drawing more and more teams out from town as part of that. So the surplus of fields relies on a network approach, and that's where, frankly, adding 10 hectares and at least 3 field units is going to address what's been planned for in both TCC and Western Bay. The other thing about the school across the road, though, just quickly, is that what we don't have evidence for is the amount of school students that will begin to play sport with the growth. So even though the population is going to be more ageing, what Smart Growth doesn't do very well is qualify how many of those people between, say, 5 and 49 will be active, and that's why we rely on that sports field demand analysis to provide those figures. So in terms of the data certainty, there's a high level of data confidence, not from Smart Growth, but from the specific sports field work. Just one more point, the Regional Sports Trust also assists this process with clubs' own aspirations. So it's not necessarily just a mathematical model. So we do hear from clubs from their national level what they're projecting for growth in their own code. That's why we have certainty around netball and football as growth areas, because they've got good evidence themselves about planning within age groups and their own campaigns vis-a-vis women's rugby union and so forth.
Thank you.
Just the obvious follow-on, is it big enough?
Pardon me?
Is it big enough?
It's barely big enough. So the school site that was designated was 8.7 hectares, and you can see with 10, you've got 3 field units, and field units is what it's all about. If you look at something like Moore Park at 14, personally, I think it needs to be bigger. Moore Park is what Amakoroa needs in terms of the catchment area, and through the failure of through Tauranga not to provide fields for Western Bay, so the Parau Farms was going to be the game changer. Parau Farms was going to take the load off Maramatanga Park and provide for something where Tauranga had provided for heaps of growth in the Bethlehem cell and the intensification there. And they had relied on other ways to do that through Smith's Farm, and even Ohauiti was going to draw people into the Welcome Bay area. However, the heavy lifting will now be done by Amakoroa. It'll be drawing people from the west of Tauranga out to sports field availability.
So the short answer is a qualified yes.
Yes, sorry.
Thank you.
This might be better asked of Jeff, but I'm just conscious of the amounts of water that these facilities will require ongoing. And has that been factored anywhere into your thinking? And if so, whereabouts? Because my understanding is that there is no water available in that catchment, ground or surface.
So Western Bay doesn't irrigate fields, and that's a great thing about where we live, is that we've got, and this particular site is better than the others in terms of the soil type, but that volcanic soil and its ability to retain moisture as well as drain well is an absolute godsend. So unlike not that much farther north, where you have to irrigate, we don't. And just quickly technically add, we're reliant on things like subtropical grasses, sorry, to be really boring. There's kikuyu, and we rely on African grasses and they can be managed as great sports fields. And then we can also deploy hybrid turf, so it's a mixture of grass and non-living things. And that's, in 100 years, we'll be doing artificial when they're more affordable, completely artificial.
Yeah.
In the meantime, we're blessed with our climate.
So there is still other water type use, needs for that type of facility other than the turf or looking after the fields. You've got a swimming pool or pool facility there, got wastewater, drinking. Those are still factors? And
There's still factors. I think we haven't designed this, and for example, this is provision, so we're providing for a space to put a pool. But there's a little way to go before those decisions are hard and fast.
Yeah.
So in terms of water use, definitely when it's being established.
Yeah.
So you would use a lot of water to get that underway. But other than that, as a park during the day, it's not a heavy water user. You're down to public toilets in a community building.
so
But
I'm aware
pools
that
are-
the policy direction is to, lower the limits. That's one I'm just a bit worried for. If this is grant or goes ahead,
Well,
someone's going to
so-
have to give somewhere. That's
Yeah, well, most pools in Tauranga and Western Bay are actually bore drawn. And in fact, all the pools in Tauranga are geothermally warmed or heated. We're blessed with the aquifers, and that's where a swimming pool would have to come from. So when you do the feasibility study for a pool in this area, you're typically relying on bore water. Yeah.
they're facing the same issue in the Mount, even with their bores. The groundwater is over allocated. So interesting, but thank you for that. Oh, sorry, one other question. It's about the co-decision making co-design with Pirirako. Has anyone had a conversation with Pirirako about what matters they might like to co-design on? Or is that not a question for you? Might be for someone else.
Well, I can answer it, but we've got a history of it, but I'll let Peter cover recent.
Chair. Yeah, so co-design with Pirirako, our history, I guess, or track record of that is, for example, Huharua Sub-Regional Park. They were involved with the development of the park design. They even sat on the hearings committee. They were seconded and had voting rights on the hearings committee that considered the reserve management plan submissions. And we've worked very closely with Geordie Shepherd and co. We had the Marae DIY event out there, which was the first ever done on a reserve, and that was a very huge event that certainly helped strengthen our relationship with Pirirako, but also together with the community. And yeah, so we've used a lot of opportunity out there with Pirirako. We work closely with them on a number of things. We've managed to secure a lot of path sites, like Mangawhai and Pukina Marama and stuff like that. That's now back into public ownership, which enables mana whenua to reconnect with that whenua, which they weren't able to when it was in the private ownership. And we work with them, for example, Kauiwi that they've been finding through earthworks out there. We've got an arrangement with them going into one of our historic reserves and reinterring that there and bringing a lot of relief to them and their tupuna. To answer your question, we haven't progressed any further with the design because until this, our process is in place, it's a chicken and egg. We're not going to invest any more time and stuff at the moment until we know the outcome of this process we're working on today. But I can definitely tell you that we will be sitting down beside Tangata Whenua before we go out even to the wider community and sports clubs and MOE. We've taken on board other input to establish their presence in the community. For example, the Omokara playground, the big mouse wheel has it's artwork on it, the etching and the concrete's all done, and it's giving them the sense of place. And we would see that continuing in this space.
So do you think, it's fine if you haven't had a conversation yet. I'm just thinking of how do we facilitate that, perhaps through part of the decision or as a condition or something like that, because I think as the council needs some certainty, Piriraka would probably be appreciative of some as well. So thank you.
I think the intention is here definitely to go forward on that basis.
Thank you. And look, the questions that the panel might ask, we're very comfortable that you move them to whoever is most appropriate. So it's far easier for us. So I've got a few general questions. So just to follow on from Commissioner Bennett's question, it's hard to find in the documentation that I've been through that Piriraka has gone, we are in support of this. And I'm not questioning, that that's the case, but there's not a lot in there that suggests they're on board with this, other than the council saying they are. So can someone help me in that space? And if that's where it's at, I'm comfortable with that, but I just...
I would echo Peter's comment about the relationship.
Yes.
It's not documented extensively because someone like myself would never attempt to speak on behalf of what I think Piriraka might. But they're a phone call away.
Yes.
I wouldn't hesitate, based on our track record, as Peter's saying, with Huharua, the way we do things around here is that once we've got some certainty and some putia, frankly, to respect their time, is to involve Piriraka in that co-decision context. So that is seeking a respectful conversation around what process should we follow before we arrive and say we want to design something with you, or we as a POGO. We've not done that. We've worked, for about 17 years now on a face-to-face approach where we listen and design process with Piriraka. And that's fundamentally a co-decision context, and things like Taha Taharoa, Ongarahu Pa, and so on, even the Pahoia Cycle Trail, that stage of discussion happens real early, and that sets parameters for us and helps us achieve our outcomes collectively. So it's just, well, I wouldn't attempt to write that in as to predicting how that would go. That's not for me to say.
Well, if I could give you an example, what if that site had values that were so significant it shouldn't be developed? Because the way that, and it's, I know there's an archaeological record for that, but I'm not sure how proactive that has been in relation to this specific activity. But the conditions for the NOR speak to accidental discovery. So the assumption is we're doing this, and now we're going to mitigate, the impacts of our activity in the event we, have discovered koiwi. So that's what's playing in the back of my mind, is at that principled level rather than, where the playing field's going and how we're going to do it. Has that occurred?
We haven't designed it, but I think those early discussions with Tangata Whenua would help us write the brief.
Yes.
Everything's on the table, so with naming, the location of things and so forth.
Yes.
Julie's, there's words ringing in my ears now that every site is significant.
Yes. She told us that earlier this week.
Oh, right. Okay.
Yes.
So it's like telepathy. But no, I think honouring those conversations that need to happen is where we take direction. We've historically taken direction from Piriraka about where things go. It would strongly influence that when it is designed. If there's any sensitivities, we would design around that.
Yes.
It's what we do. I think in terms of accidental discovery and the Act, we obviously follow that to the letter, but the relationship we've got with Piriraka has been one where we've stood shoulder to shoulder in developments for reserves and altered things as we have needed to.
That's very encouraging. I don't doubt that. I'm just trying to get it clear as someone that's...
If I just could add that, Greg, when Philip Martelli was here, he was a resource planner, which is Natalie's old role. He had a lot of early engagement in this planning process.
Right.
And I've been on site visits with Julie around all the gullies and that type of thing.
Right.
And our options paper that we put out with the 7 options, bring it down to 2. Those have all been engaged with Tangata Whenua, as I understand.
That's useful. Thank you.
And also, there's been an open opportunity through the public process as well as our separate process and direct thing. So we haven't had anything come back saying, no, this is no showstoppers, so to speak, from my perspective, that I've been made aware of. So.
And you've been involved for a very long time. If there were showstoppers, would you expect to have heard? Because
very, very quickly.
Yes, that's great. Thank you. And so in that sort of following along in that theme, there's a couple of general things. The gully head that's shown in the concept plan, part of it's outside of the NOR, but part of it's inside. Would the applicant be kind of averse to seeing that secured in the notice of requirement? Because at the moment, I don't see, the conditions don't secure that natural open space that's there. Because what you're describing is right on the money.
Yeah, through you, Mr. Chair, we own that bit of land.
Yes. So the inside the red line I'm talking about. So inside the NOR, the very head of the gully. So
part of that we would need to just look at the titles again.
Right.
But part of on the inside, but also the other side is we own that land there as well.
Yes. Okay. So it's just to stop, you get the wrong parks manager, and they go, no, that is actually a really good spot for a full-size hockey turf, as opposed to natural open space.
I am aware there's been a bit of a historic dumping there, so there's some geotech issues we'd need to work through there.
Okay, right. Thank you for that. And in that same vein, you were talking about the bowling club moving up here and the challenges that are down that coastal margin. Do you see that as an opportunity to utilise that coastal margin in a way that is more sympathetic to that use of a coastal margin than perhaps a bowling club? Are there kind of dual benefits that accrue from this?
The site's a good site, and typically some of those banks that have been affected by slippage, this one hasn't, have been rehabilitated into more of a habitat. It's still a bank, so it can't be a walkway or so forth. But when the bowling club goes, it will leave some flat land where Mokoro is intensifying. So it does always provide other opportunities.
Yes. Thank you. And you might have already covered the last question for me. We've heard a lot this week about the ageing population. Are you satisfied that the profile at the conceptual level that you're setting out here provides for the needs of the ageing population?
Yes, in terms of ageing population and the fact this is yet to be designed, we would go to another level of process around that. Mokoroa is a community that's good at coming forward and quite articulate around their own research. So we've seen tennis courts happen and things like that.
Yes.
So I think here we would be pretty hardwired into what people think they want as well.
Thank you very much. I really appreciate that. Are there any other questions from the panel? Thank you. That's very useful evidence. And thanks for the questions from the rest of the team.
We'll now ask Ms. Badenhurst to speak to her evidence.
Good morning. My name's Annelie Badenhorst, and I will be talking about the acquisition strategy that Council has compiled regarding engagement with the affected landowners to acquire the land for active reserve. I am employed as a legal officer within Council, and as such I provide legal and strategic advice to Council on acquisitions and disposals, specifically working through the mechanism of the Public Works Act. My involvement in this process was twofolded. Firstly, we contacted the landowners. We made initial contact to gauge their view on Council acquiring the land for active reserve purposes. And secondly, we then compiled an acquisition strategy, setting out the timing for the actual acquisition of the land and taking various factors into consideration, such as the timing for the actual development of the land once it's acquired, what Council's holding cost would be, what our planning would be around that, all our financial impacts, looking at all of the land individually, looking at all the interests registered against the land, what the actual current land use is. So we first approached the landowners during March of this year, and we spoke to the landowners at 7 Prol Road, at 468 Amakaroa Road, 474 Amakaroa Road, and 454 Amakaroa Road. When we specifically spoke to the landowners at 7 Prol Road, they voiced their preference that should this designation go ahead, that they have the option of given other land by council, so that council would effectively enter into a land swap transaction with them. We initially identified 25 Prol Road as a possible relocation, since council already owns 25 Prol Road. That property is effectively next to their existing land, and it would tick all of their boxes, since it would be right next door to their current property, and obviously help with the feeding into the primary school from their preschool facility. But we then realised, after talking more internally within council, that unfortunately 25 Prol Road would not work, since there were other plans already set aside for that property, including a link road to be built, which would essentially go through the building platform and the existing building on 25 Prol Road. We then looked at other options and identified another property, being 29 Prol Road, which is not owned by council. It was owned by another landowner. We reached out to that landowner, and they advised that they would be interested or wouldn't be opposed if council wanted to acquire that land. And we then arranged a site visit, and the landowners after the site visit indicated that that site would not work for them, since they've got certain matters or that they need to comply with in terms of their license with the Ministry of Education, and I don't think that property could have make it work for them. I think they've got 45 children, and I don't think that property could house 45 children. So after we then spoke to the landowners, including 7 Prol Road, we then realised that we had to compile an acquisition strategy, since there were 5 properties involved that council had to acquire. We couldn't work with them on a piecemeal basis, and we then advised the landowners late May and early June 2023 that was council's next step, that we were going to compile this strategy and then come back to them as soon as we could afterwards, to give them comfort that we were looking into the matter and that we were going to put a robust strategy in place, whereafter we could then continue further negotiations or discussions with the landowners. So there were various considerations when we developed this acquisition strategy, one being holding costs and the timing for the development of the actual reserve land, or land earmarked for reserve, since it was only anticipated that the actual reserve land will be developed during the next 10-year annual plan. So money has been allocated from 2031 onwards for the land to be developed. So in other words, during this 10-year term, specifically 2024 and 2026 have been set aside as the timeline for council to acquire the land. So budget's been set aside for that, and then budget will be available as from 2031 to start developing the active reserve areas. So we had to consider that, and then obviously also council's obligations in terms of the Resource Management Act and the Public Works Act, and we had to take into consideration the landowners' concerns and objections, since they were being affected, obviously, through this whole process. So the outcome of our strategy was that we would actively go out and acquire the land 2 to 3 years prior to the development of the active reserve. Since we came to the conclusion that the holding costs for council would be too high if we were to engage earlier, but that could be mitigated or remedied by the fact that we were not opposed to acquiring the land earlier, even as early as 2024, but with a leaseback provision being in place, so that once council's acquired the land, the landowners can then, under the current land use, lease the land back from council, which would then obviously help with the maintenance of the grounds. There would be an income stream for council, which would mitigate our holding costs and help with our financial costs. And then once, yes, so that was basically what we came up with. So the option is there for an early acquisition, or if they would want to wait until 2026, 2028, council will then proactively bring the process forward under the Public Works Act, which is a different process than under the Resource Management Act. The circumstances which we would consider for a possible earlier acquisition is, like I've just stated, if the landowners approached council and wanted council to buy the land earlier, or if it became apparent under Section 185 of the Resource Management Act that because of the existence of the designation over their property, that it would make it harder for them to sell their land, that council would then intervene and purchase the land sooner. Or obviously if they were to put their property on the open market and wanted to sell it, then council would consider purchasing their land sooner as well. We came to this conclusion by analysing each property, whereby we looked at the ownership, current land use, what the registered interests are. We looked at a high-level compensation estimate that we compiled, and we looked at all of the financial and lease information that we had at hand. We did desktop valuations for all of these pieces of land so that we could gauge how much it would possibly cost to acquire the land. And each of the properties have been considered in light of the potential purchase price offset and the associated risks to council regarding holding costs. There is an argument to be made that it's probably a good time to acquire land right now because of the market having slowed down, but that the fact that our holding costs would be so much more if we acquire the land too far in advance sets off against that positive and would actually make it much harder for council to acquire the land. Once we then compiled this acquisition strategy, we sent out an email on the 18th of August to all of the landowners, which is attached to my evidence as Annex A, whereby we informed them that we were planning to actively acquire the land between 2026 and 2028, but that we invited them to have a discussion with council should they want council to acquire the land earlier, and that we would consider that against a possible leaseback option, and obviously on the back of the Plan Change 92 and NOR designation being successful. We followed that email up with another email on the 4th of September, and to date we've not had a reply from any of the landowners regarding those specific emails that we've sent.
Thank you.
Jim, if I just could add to that too, so that offer lies on the table.
Yes.
For that early engagement, Tobling.
Yes.
Thank you. And just from a funding perspective, council's had in its 21 to 31 long-term plan, which was adopted back in 2021. We've had the funding in place for the land purchase, and as I was explaining before, until we know the outcome of this process, we haven't gone through the detailed concept planning phase with the Pitarako and the wider community. So until I can get to that point, understand what it is the community wants on that space, you know, in more detail, and then we can cost that out, and that will go into a future long-term plan, which we're currently working on one now, but the timings, I don't know whether we're going to get the same time for the 24 to 34 one, but definitely in the future one, all the development costs will be definitely put into there, but there are some holding development costs in place now. We just don't know to what level of detail we have yet. So it's that chicken and egg situation for us as well. And one more thing I'd just like to say on the planner's report about the designation and an RMA not preventing the possibility of that storage business continuing, we wouldn't unreasonably withhold consent for an extension to the activity if it lined up for everyone.
That's good to hear you comment on that, because it's going to come up. Thank you. Right, questions from the panel? No, nothing from me. That was very clear evidence, really helpful, very honest. Thank you very much.
Last but not least, Mr. Hexel.
Good morning. Thank you for the introduction. Perhaps just briefly, I'll just comment on a couple of matters that have been raised before I respond to some of the other matters that have come through evidence. But that's one thing to just put into clarity, I guess. You know, the key objective of this is to provide an active reserve, to provide additional recreational facilities which are necessary to serve the projected growth demand in the community. So it's a very clear what's trying to be achieved. The question was raised about the gully head and the interrelationship with the active reserve. Hopefully what I think's hopefully coming through is that council operates in an integrated way. So although you may have a active reserve boundary and you may have other reserve areas, the reality of how it's operated isn't that black and white. I think Mr. Watson can probably concur that a lot of the stormwater reserves have multiple faceted recreational reserve or walkways, etc., combined with them. So it's actually quite common to have that kind of crossover, shall we say. The micro gully reserves concept plan, which I think you're familiar with, you'll see that the active reserve is actually a key component of that. So if anything, the title of that plan is probably a misnomer, because it's far greater than that, and the linkage is quite clearly showing how they work together. So they do work as a package. The actual reserve status for this is quite different because we're looking at the active reserve, but the nature of where those property boundaries are, there's these crossovers into that natural open space zone as proposed. But we look at both, as shown in the concept plan, how the practical fields will work, plus those wider functions. So it's kind of, they do work together. Commissioner Bennett introduced questions about water and those aspects. So when the structure plans are designed, they don't just consider residential use, they consider the wider use. Whether or not a future pool has been considered, I cannot comment on. I suspect probably not at that level, but again, we'd have to get the council engineer to make any comment on that. But the structure plan looks beyond just residential, looks at the whole package when they do the modelling on this. Just turning briefly to the submissions that were received, as been pointed out, there were 6, 2 in support, and there were opposition from parties who we're going to hear from shortly, who have interest in land. I also note that the 3 parties with land affected did not lodge submissions on this. I will note that one of those, though, is the council. Just very briefly, because I think it's well laid out in the application documents and evidence. Mr. Jacobs and Mr. Cummins, I think, are here. They've got concerns, obviously, about the childcare, which you'll hear very shortly. Theirs is in a slightly different situation than some of the other landowners, where it's been very clear direction or identifying that the council has got strategic interest in the land. They have a resource consent that was granted without such a sunset clause as they have in others. So their issues, I'm sure Mr. Cummins will articulate very well that they have gone through this process. They've gone through a whole resource consent process to get established in that area, and now they're having to deal with this situation. I think just following on from Ms. Badenhorst's comments, I mean, council is very keen to try and resolve issues with people. They've been trying to find alternative sites. There are other land developers doing things in that area, and when we try and get people to join together to try and find solutions, that's what we look at as much as possibly. TDD and Mr. Taylor's here today. Their concerns again have been a lot about process, and certainly, and again, Mr. Madhurst has talked about some of the issues going on, and also Mr. Watson. I think the key thing of their issue is it's got a consent. They had an expiry date of 18th of May 2026. Mr. Taylor in his evidence has actually included the part of the consent decision. I think it's probably worthwhile reading it out because I think it shows how the council has sort of considered forward thinking on these aspects. It actually says the committee noted that by limiting the life of the consent could allow facility operation to be revisited in the future. Whilst the imposition of review conditions could be imposed to deal with any effects that may arise from the operation of the facility, it was determined by the committee that a ceiling be placed on the activity such that at a predetermined time the applicant would need to reapply, and assessment at that time could have regard to the operative and or proposed plan requirements in place, and that time of any other strategic and policy documentation. And as I've previously noted, that the expiry date was 18th of May 2026. With the progression of PC 92 still subject to obviously decisions, we are now at a stage where those decisions can be made. So I think it sort of shows that council has tried to be fairly consistent. I think there was a slip up in the council's consenting regime when the consent for the childcare was granted, where they didn't put such a condition on. And I think that's made life a little bit more complicated for people. But it is a matter of fact that's how it was, what occurred. Mr. Taylor's submission clearly identified the matters which they were asking council to address. One was that council consults with TDD Limited in relation to the timing and progression process for the acquisition of our land, that a master plan be prepared that shows the need for our land, that certainty is provided in relation to timeframes that will enable our investment decisions to be made in relation to the continued operation of our storage business, and 4, that the council commences a process of land acquisition and discussions with us. I think matters 1, 3 and 4 have been addressed in previous evidence. Mr. Taylor states that the notice of requirement effectively sterilises their land and does not enable them to continue with the existing business. The legal status of land affected by designation has been addressed in legal submissions. And I note that Mr. Taylor gives the example of if they wish to apply for a new consent to extend the existing operation. So based on the assumption that designation is in place and the underlying zoning is medium density residential, a new application would fall to be considered as a non-complying activity under current legislation. Any such application will be based on more certainty as to when the council acquired the land, and it would be expected that a fixed term consent could be considered favourably. I think Mr. Watson has said if it actually is, if the timing works out, there's no opposition from a council perspective about trying to supporting such an application if required. Contrary to the legal submission on behalf of TDD states that there is a strong likelihood that council will not provide approval if her clients wish to seek an extension of consent. And again, I'm not sure the basis of that is, and Mr. Watson has concurred that council is very open-minded about this. They want to work with the parties involved to get the best result. And there's also interest for council that if they aren't in a stage to develop the land, it's better to have a commercial arrangement with the landowners, continue use. So it's going to be a win-win situation in it. It's obviously a process to go through, but I think the key message is council isn't going to try and stop those extensions of consent if that fits into the timeframes. The legal submissions, again, on behalf of TDD, appeared to challenge the need for the reserve. Again, Mr. Cannon's expert evidence, I think, has clearly laid out why there's a requirement for a reserve and also why this particular location is the most appropriate. There's also submissions in the legal submission again about the concerning the proximity of the industrial zone. I know the commissioners have been to the site. You'll see the commercial, the very light commercial or industrial, semi-commercial activities in place. There's also separated by Mokara Road. There's a 10-metre landscaping requirement for industrial uses. There's also, on the concept plan, likely to be landscaping adjacent to Mokara Road. That further separates reserve activities from industrial activities. So I fail to see much likelihood of the, I think we had pollution, all sorts of odour effects that were going to make people on a sports field suddenly feel unwell. It's an interesting comment. I also think the other part of it is that by being located to what I've called activities which are not noise sensitive, they're actually very good for a reserve. So on a Saturday morning, they can be fairly raucous places, as they should be. We've got a zonings with across the road of a school site. We've got that industrial on the other side. We have the gully network. We've got to have some medium density on one part, but that's also going to be separated by some car parking. So overall, when you look at those, how they interact, it's a very, very good site from that perspective as well.
Sorry, just to put in again, Mr. Chairman. Just to give us some context too, another local example of industrial background, if you ever watch the international cricket or hockey at Blake Park, you'll see the Port of Tauranga industrial area in the background there, and that functions very well and meets compliance of international standards of thing. Centennial Park in Te Puke too is actually on industrial zone land and has a backdrop of industrial activity in that area there, so that too can coexist.
Notwithstanding the air quality issues.
Yeah. Oh, use within an element.
Yeah, that's useful. Thank you.
Thank you. So the need for the active reserve, I think, has been clearly articulated. The notice requirement and sort designation is required to safeguard the land area for active reserve purposes. This, in my opinion, represents good forward planning that has been consulted with the community for a number of years. By being future focused and going through this process, the council is providing for the needs of the community and noting the planned increased urbanisation of Makaurau. It is far more difficult to achieve and expensive to try and retrospectively acquire land suitable for active reserve purposes. And again, Mr. Canham has articulated that very well. Just turning very briefly to the reporting officer's report and his further evidence. I've read the Section 42A report and reply. I agree with the findings and support the recommendation. I've read the updated recommended conditions of the reporting officer and agree with the changes in the overall condition set. Thank you.
Thank you very much. Questions from the panel?
Yeah, I've got a couple. The condition set that we got this morning, are these additional to the conditions in the NOR, in the original notice of requirement, because they're quite different?
Those are a tweaked version of the conditions that were presented in the original Section 42 report, with the additional conditions being 2 and 6, sorry.
Sorry, maybe I need to rephrase that question. There are some proposed conditions in the notice of requirement, and there are some pretty key conditions around reserve management plans being prepared and outline plans. And I just wondered, are these that you've circulated, are these additional to those conditions? Because those conditions would be required.
Sorry, just for clarity, you're talking about the conditions that were proposed by the applicant?
Yes.
Yes, so those conditions have, I guess, been distilled down and are reflected in the draft conditions that you have in front of you.
Because what I'm not seeing is a condition for a reserve management plan anymore. I'm not seeing a condition for an outline plan condition under Section 176A of the RMA. And I just wondered why those have disappeared from this set of conditions, because to me those would seem critical. There's also, sorry, when I go closer it seems to not like my voice. So, then there are a bunch of other conditions that in reference to Commissioner Bennett's comment earlier, it seems that you could look at a mana whenua or Perirako partnership condition. That's quite standard in a lot of NORs now. I've been doing quite a lot of work on NORs recently. Also, some form of stakeholder communication and engagement condition.
Again, they're quite standard now. Something that's along the lines of activity in general accordance with the outline plans and information, again, that's not in here. And you might also want to think about property management conditions in light of your conversation or your discussion around when you're acquiring property and whether you are going to be leasing it back, you might want some form of property management condition. So all of those seem to be absent from the suite of conditions that we have sitting in front of us, and I'm a little bit concerned about that.
Perhaps one way to work our way through this is we're going to take a break for smoko in a second once we've finished general questions. And when you come back after the break, the team can have had a discussion and provide us some feedback in a slightly fuller way on that.
Yes, fine, sir.
Right, thank you. Is that going to be appropriate for you as well?
That's absolutely fine.
Thank you. A couple of very sort of operational questions. You described the consent that was issued without a fixed term for the, I think it's the childcare facility, as being complicated. Do you mean by that complicated for council? Because it's probably not complicated for the consent holder.
No, I think it's adds a degree of complexity to this process where you have for the other situations, we've had very clear documentation about consent timeframes.
Yes.
This one didn't, so that just adds, that there was obviously, Mr. Cummins will tell you there's an expectation they have a consent, and it's a resource consent that doesn't have timelines on it, so this means it is different than, say, some of the other properties.
Yes, so they have, in this case, where you have certainty in relation to storage about end of consent and future land use. In the other case, the consent holder has certainty about their rights under the Resource Management Act until a process like this. Right.
That's correct.
That's helpful, thank you. And then just looking back at the concept plan for the concept master plan for the site, and I think it came up in your evidence, the new road future connection. Can you just talk about that in relation to the relationship between the structure plan we've been dealing with under the Section 90, the Plan Change 92 process, and this in terms of the way that new road relates to the gully system, the open space?
So yes, there's a new road in the structure plan. So it's basically a link road. It doesn't drive into the gully.
It doesn't now, but I'm assuming it goes somewhere.
Yeah, so you've got medium density zone land on to your northern side there.
Yes.
So it'll help to feed into that and also provide access into the reserve.
Oh, so it does not cross the gully?
No.
Right.
There'll be another major exercise, that one, yeah.
Right.
So the only road it crosses through is the link road between Prole Road and Francis Road, which is a major one on the structure plan, and also a very expensive one because of that very issue.
Yeah, thank you. No, that's good to have that clarified. Thank you.
Perhaps I can also just point out too that shown on the structure plan is there's a plan to be the underpass to the school.
Yes, yes.
So that's my understanding, talking to the project manager today, is they're looking to do that as part of the Prole Road urbanisation project, which is currently on.
So let's just finish this one. Just show me on the structure plan there, just exactly how this plays out so that it's not in the gully system.
So where are we? So we come through here. So that comes in and it links through there. It's probably not very good at scale.
Oh, right. That's fine. So it's coming in and then just turning to the north.
Yeah.
Right. That's useful. Thank you.
Yeah, and you'll see the major road.
Yeah.
And that's the key link across, and also, as we discussed the other day, it's also going to allow the people in this development to come through to this area that way.
Yeah, that's great. Thank you. And it comes back to the evidence we had a little earlier on. So things like the underpass, the Ministry of Education will come to the party for that.
Oh, there's still negotiations, and I think also I think the issue currently is just sorting out the final funding. It's a provisional, or was a provisional item on the initial contract for Prole Road. My understanding that's now progress. So I think they're actually looking at construction next year, but it won't be opened up. It'll be obviously until it's needed.
Yeah.
But it's just from a financial and logical, it's better to do it at this point, rather than try and retrospect it in 5, 6, whatever years it's going to be required. So that's quite a key component on it.
And it might be a question for another witness, but in relation to the Ministry of Education's, you know, the benefit that accrues using broader publicly owned playing surfaces, do they ultimately, in your experience, do they ultimately come to the party, or will they avoid making a contribution if at all possible?
Great question. In my experience, they're quick to leave the room.
Right.
Yeah, so they typically say, well, we're providing the activity, so but not a capital investment at all.
Right.
They're likely to integrate it into their syllabus for taking, you know, students to the reserve,
Yes.
which is what the reserve's for. But there's no real relationship with council's recreation provision or programs or anything like that.
And do you
certainly
have
no money changes hands.
Do you have the ability to recover costs from the Ministry of Education Ministry when they're bringing students across?
You can try. But typically sports field policy, we want to enable recreation.
Yes.
So in the past, that may have attracted a booking fee, and it could still be a discussion.
Right.
It's one that's raised often, but
Yeah.
schools are quick to say, well, what are you going to do?
Yes.
Are you going to kick us off the park? You know, so it gets a bit logical after that.
I think in this time there's actually still live discussions on this because it's also a big safety aspect. So that's probably a little bit different. This is actually a key safety to get people from one side of the road to the other.
I accept that in relation to
so
the
I think
underpass.
there's definitely still discussions, and I think there's that may be a little bit different than others than how it turns out.
Yeah.
So
Thank you very much for that.
Just through you, Mr. Chairman, just to help clarify, so out at Te Puke, they do lease the domain, but that is a historic lease arrangement, which
Right.
they have tried to get out of, and we've held them to account on that. But we would be looking at something similar to here if they wanted to utilise, you know, publicly funded or ratepayer funded land for provision which perhaps they should have supplied. But we also do require, we have a booking system for all sports grounds. One of the reasons for that is obviously avoid conflict. We can manage our innovation programs around that, but we also use that data to supply into that demand analysis that Jeff talked about for our future demand analysis needs like this situation here. Yeah.
Thank you. I know it's a little out of our purview, but it's useful context. Well, look, we'll take a break till 11 o'clock and then be back. And so if we can get a response, and it's fine if it's coming from both sides of the room in relation to the conditions issues that Commissioner Mean was raising. Thank you. Right, when we left off, the planners were going to have a discussion during the break. Is there any feedback now, or is it more likely we'll get it either in right of reply or later in the afternoon?
I think Mr. Danby might just speak to the conditions.
Right, thank you.
Thank you, Commissioners. So we're open to drafting conditions as required, just recognising that obviously will require a bit of wordsmithing and it's not something that we can necessarily turn around today. However, it's probably maybe useful just to, I guess, explain a bit of the background behind the conditions that you've got in front of you. And essentially those are about recognising process under the RMA. So assuming that the designation is confirmed, then that sets off the requirement for an outline plan of works application to be submitted to council. So the expectation is in that situation that once the designation is confirmed, then the council will be required to submit an outline plan for development of that reserve. So that's why there's no specific reference in those conditions to the requirement for an outline plan, because that's, I guess, a given under the RMA. There's no reference in there either to a reserves management plan. That obviously doesn't exist at the moment. And if in the future the land is classified as a reserve, then it will be subject to the Reserves Management, or the Reserves Act, sorry. Yeah. And there'll be a reserves management plan associated with that that will then govern the use of that land. So again, a separate piece of legislation governing that process. And I think in terms of the concept plan in front of you at the moment, it is just a concept plan. So there is some, I suppose, reluctance to lock that in through conditions of a designation, because that may change once these processes of consultation, etc., roll out after the fact. Thank you.
Thank you. Any other follow-ups?
Yeah, I don't think I referred to the concept plan because I realise it's a concept. I think it's more making direct reference to an outline plan of works, because that is quite a standard condition these days in NORs. So in the conditions on NORs, so I would expect to see something along those lines.
Thank you. So we might talk about this further this afternoon. You'll be back on with us. We are moving to our submitters now, and I think there's been a bit of rejigging in the break. So who was going first? Sorry, Georgina.
I think Aaron Collier might have to go first, because I've just heard that Kate from TDD has to leave shortly.
Right.
Yes, but
Yes, thank you, sir. Can you hear me?
Those legal submissions may have an impact on all the submitters.
Right. Well, look, we've got a submitter at the desk. Are you happy to just stand down for a few minutes while Ms. Barry Pacino does her thing, and we'll have you back? Is that all right? Thank you for your tolerance on that front. So, Ms. Barry Pacino, the floor is yours. Morena.
Morena, thank you to the commissioners, and thank you very much to submitters that are in the room for allowing me to speak. Apologies, I had some time this morning, but just it's running a bit tight, so I was just hopeful if I could speak first. And then my client who's there, Mr. Taylor, can speak, but I'm very grateful to the other submitters if they allow that to happen. If I could just commence with stating that I have heard all the evidence this morning from council, and I would suggest, with the leave of the commissioners, that with my legal submissions being taken as read, and I have heard the council's legal counsel submissions, the principles around NORs, it's obviously the commissioners are very familiar with that process and the legal concepts behind it, so I won't dwell on that. And I will try and deal with the two aspects that are factually relevant to my client and both the other submitters too, with regard to some of the issues around the plan change itself. If I could focus firstly on the aspects around where the evidence from Mr. Taylor and his submission and my subsequent legal submissions focus on the substance and justification for the plan change itself. As I stated in my legal submissions, the general principle around the need for open space and active reserves within growing areas is not challenged, obviously. Where there is a challenge that in my submission is front and centre for TDD's submission is the lack of credible evidence that's beyond a superficial nature. It's given me grave concern this morning to listen to Mr. Canham's evidence and listen to a whole lot of new evidence that's been provided verbally that was not included in the Section 42A report, that's not included in a business study that's been transparent to the community. And in fact, that evidence that he provided seems to be heavily premised on three matters that give me concern around the evidential nature of the business case and justification for this plan change, given that we haven't heard from the parties that he has asserted evidence almost on behalf of, or at least asserting in terms of a position. The first one relates to Tauranga City Council. If the reliance on this designation is for the purposes of Western Bay sub-regional needs and driving that as a need because of a lack of service or a lack of active reserves provided by Tauranga, then surely you need to hear evidence from Tauranga City Council to verify that information. That's significant evidence that's being asked by you to rely on, being provided by Western Bay, asserting the needs and demands of TCC, to which TCC has not provided evidence on to confirm that. And in my submission, you need to hear from TCC, because the immediate concern that I have is that the second aspect, which provided through legal counsel, was that they said that the traffic effects had been addressed through Omokoroa's urbanisation. Now, that may address the traffic that results from urbanisation of Omokoroa, but it doesn't address where this particular active reserve is meeting needs for active sports fields and competition sports from around the Western Bay. That's a completely different traffic effect that I have not seen any evidence on that Western Bay has provided. And in my submission, that's significant. You have already huge traffic congestion out on that same route out to Omokoroa in terms of commutes. Now, if that's going to be after school sports that are a sub-regional midweek type of competition, which does happen and causes significant congestion demands, and I can say personally as a parent driving children around Western Bay from one end to the other to a 10 sports ground is massive in terms of what that does to the traffic network. So that's important to know. Has that been considered? Because if Mr. Canham is correct that TCC is relying on Western Bay to provide its needs around active reserves, what does that say in terms of any rate paying sharing, capital cost sharing? Again, haven't heard anything. Second of all, would it be in Omokoroa given the traffic congestion and distance that is? In my submission, I would suggest that that's highly unlikely. It's far more likely that they want it to be in Western Bay, located far more close to a central nub between those two jurisdictional boundaries and needs of where growth is in the city as a whole. It would not sit out in an outlier suburb city satellite of Omokoroa in terms of needs of the Western Bay as a whole. The second concern that I have is the evidence provided again verbally by Mr. Canham at this end of the hearing without verification or credibility heard from the Ministry of Education, that he stated that the policy is that Ministry of Education is no longer providing green active reserves, and that it is reliant again on councils and ratepayers to pay that. Given that the Crown is not subject to paying FinCos, that's a really important consideration. And whilst I accept Mr. Canham's evidence that he's involved in lobbying down in Wellington or otherwise around what that might look like, that doesn't give any security to the council, to the ratepayers, and most particular at this aspect of the designation part, the landowners. Where is that money coming from? And how is that going to be developed? And it sounds like Mr. Canham doesn't have the answers to that either. And it's certainly not something that's been put in place at this end to justify a business case around what is a wonderful concept plan, looks great on paper. Wouldn't we all love it? But who's going to pay for it? And I'm involved quite heavily on the landowners and developers in Wairakei, and I'm very aware of what happened there through what Mr. Canham referred to as the aspects of that. I'm also very aware with Smith's Farm and Parau Farms. Now, all of those decisions by Tauranga City Council to use those for housing, to reduce the number of reserves, was based on business case studies around the needs of the community that were reviewed over time in terms of where those needs might come from and more pressing needs, and also costs around reserves. In Mount Maunganui and Papamoa, for example, there was a reliance on the beach to provide active reserves to reduce FinCos around reserves so that land and housing was more affordable, because the costs of the FinCo loading was meaning that housing was being delivered at a much higher cost than was affordable to the economy. Now, I don't have the answers here, but I do say that those are very nuanced technical assessments. And I haven't seen any of that evidence to justify this designation. I'm hearing evidence that Mr. Canham's turned up verbally today without any submission from the Ministry of Education, without any submission from TCC. And yet both of those seem to be a strong reliance on the business case justification for the designation. Again, as a matter of natural justice for the landowners affected, in my submission, the council has a duty to provide that evidence if it's going to be relied on by the hearings committee to justify this notification in its current form and designation. Because those two parts of its business case has not been presented in the Section 32 analysis or the Section 42 report in anything other than a superficial, broad nature. The other aspects that I covered in my submission was the aspect to which the relationship with the college and the schools around those facilities and cost sharings. Again, one would expect that to be at a more sophisticated state before it be relied on in terms of the size of this designation. I'm aware in Papamoa, for example, in Wairakei, with the recent costing that we did in that regard, and while it's none of it's been got to designation stage, the initial costing, I think those discussions were some 2 or 3 years ago, there was a costing, and it was $70 million just for a 25 square metre type pool facilities. These are massive costs on ratepayers, and one would expect that those costs and who they're going to be worn by and at what level per rates per year is a full discussion with the community. I was heartened to hear the discussions from the hearings panel and questions around the relationship with Wairakei, because to my mind, the lack of evidence from Wairakei is the same concern I have with the Ministry of Education and TCC. There's a lot of wonderful talk around this will all be fine, and same with the landowners, but we haven't seen it in evidence. It's not matched in written evidence or hearing from those parties about what's going on. The concept plan that's been put forward, again, if it is what is going to be put forward as a justification for this designation, why is it not reflected in the conditions of the designation? If there's a promise of acquisition and plan for this over a 5-year period of time, Why is the designation not for a shorter period than 15 years? Why are these dates being put forward, yet there's 15 years being sought on the notice of designation, not 5 years? There's a lack of, I guess, transparency or correlation between what's being asserted verbally and what the conditions of that designation state. And I would like to see those conditions, if this is granted, to be based on an adjournment where some of this evidence that's being asserted is actually verified by this hearing panel from the parties that are being used as third parties to justify the business case for this designation, and that's been sought and provided to this committee. I would like to see the conditions be redrafted to address some of those matters that have been raised and that are being raised by ourselves, to address, for example, the outline plan, the concept plan, the staging, the timing. There's a lack of that scrutiny that's reflected in the designation. It's very blanket, very superficial at a level that doesn't justify what's being spoken here today in terms of evidence. And the other aspect that I raised in my submissions, and I'm just going to say this anecdotally, that I've just been in a conference on behalf of TET, which was the Philanthropic New Zealand conference. And part of philanthropy by community foundations is giving money to a lot of sports groups. And we're faced with competing clubs for that dollar, for that community dollar. So in that way, we're juggling the same aspects that councils are. And we heard from Paul Spoonley, who probably the Commission hearings panel may have heard of, is very much interested in population changes and what that does in terms of what New Zealand's emerging society is going to look like. And it's very different looking ahead to what we have now. And he talked about that in the context of not just an aging population, but what a population look like going forward in terms of sporting and recreational demands. As he says, cricket's almost out the door. No longer are young people, it's dropped 50%. Rugby, similarly, massive decline in demand, although it's raising in women, they're holding its own in terms of bringing that sport back up. Where you have the greatest growing sport, it's table tennis, because of the increasing Asian population that we have. It's pickleball, it's basketball. These are indoor facilities which require different levels of active reserves than what the current community, if you sought feedback from them, which maybe, I'd hate to say it, but you or I or Mr. Canham age group, what we think our community needs and what a future young people's demands are, they don't do as much organised sport. They like more flexibility around how they play, what they play. They've got more demands. Young people with working lives don't want those commitments. Now, I don't have the answers to that. All I'm saying is that takes a much more nuanced, discrete look at the needs for the next 50 years or so of looking forward if you're asking current ratepayers to fund this. And that must look at the size of land that you're taking. And if that means a staged approach to that, so be it. And that also goes to when that's weighted in terms of costing to ratepayers. And I would expect that if there is going to be cost sharing, that's secured in a better way before there's this huge commitment. It's either that, or if, as Mr. Canham says, and I accept that a council has to act quickly on land acquisitions. When I've been involved with Tauranga City Council around those types of acquisitions with affected landowners, they do act quickly and they do acquire the land and they might land bank it. But again, that's secured with respect for the landowners in a way that I haven't seen to date here. I've seen a lot of talk, but not a lot of commitment. And I think that's where you have the lack of trust that's been reflected in Mr. Taylor's submission that he entered into consultation in good faith some years ago and hasn't seen any results around that. And I just want to challenge some of the aspects where that's stated in terms of the restricted limited life consent. It's important to note there that Plan Change 69 was some time ago, and I'm not sure if Commissioner Withy was involved with that, but I think he may be familiar with it, was that was where the active reserves was going to be on the Gain farm, which is now where the school is. So when Mr. Taylor had his consent granted and there was a limited life for that, that was on the basis that it would be needed for residential. And he accepted that condition and didn't appeal it because he also expected that he would be utilising his land for future residential rather than the business in the future. And storage sheds work well in the sense that they're not a huge capital investment in buildings as opposed to other forms of use that could work in a limited space. And so the reason for that being accepted on his is quite different setting than the childcare facility, which has substantial buildings and investment in what it put there. So it's completely reasonable that it didn't accept or get a limited life consent as opposed to the storage sheds. The other aspect I wish to touch on is the way in which the council has responded to the issue that I raised in my submissions around the adjacent industrial zone. Firstly, I'd like to state that whilst I've been well familiar with that industrial zone and adjacent rural neighbours who opposed it, because their understanding, again, on promises of Western Bay early on, was that that was going to be compatible with them and rural residential. Turned out not to be at all. There's no restriction on the types of industrial use in particular in that place. And the council themselves was looking very closely, and they may have walked away from it now, but to put a transfer station on the corner of that at the exit way. Now, they may or may not have walked away from that, but the council can update you on that. But just to highlight that what may go there is not controlled in any great sense in terms of saying it's all going to be soft industrial. What's there now may not be there. It's still a growing industrial zone. The second aspect of that in terms of the references by council is saying, oh, well, there's cricket fields and hockey fields in the industrial area at the Mount. That is not going well. If there was any understanding of, and I think that Commissioner Bennett would understand this and be well familiar with this in the context of Ngāti Kuku and the concerns there that have been raised on the air quality space, that those aspects of land use conflict between open space and sport and children being exposed to air quality issues is a really important issue. And I know the chair was also involved in that recently as well in the Environment Court. So those are issues that you as commissioners do have to think about. It's not what's there now, it's what could be there, what's enabled in those zones over the next 30 to 50 years, and what is the anticipated potential conflict? What might that look like? And does that mean that this land is more suited to closed type of recreational facilities as opposed to open sports fields ones? I don't have the answers to that, but to dismiss that in the way that was suggested by the council as unusual in terms of being raised in my submissions, I think is both disrespectful and unrealistic in terms of conflict between those types of urban uses. So in my submission, at this point, although my client in good faith would like to say that it supports some broad concepts around engaging with council around active reserves, the lack of information and credible probative evidence to justify the designation in its current size and extent, without the business case there, it's declined. We seek for it to be declined in its current state, or at the very least, that there's a shortened designation period to actually force the council to see whether it's actually serious and puts the landowners out of the level of uncertainty and planning blight where it can't move forward or move backwards. And that's really the sum of our submission.
Thank you, Ms. Barry-Pacino. Are there any questions from the panel? Look, my only question for you is in relation to term. you said a shorter term, I think it's 15 years at present. What
I would
is the
say
term?
to fall back on the default within the Act, sir, of 5 years.
Thank you very much. Thank you for your contribution. Look, I'm just wondering, in fairness to the team that were at the table, whether we have them back or whether we need to hear from Mr. Taylor right now. Are you pressed for time and that we could not go back to our original schedule now?
Sir, I would leave it to Mr. Taylor and Mr. Collier who are in the room.
Yes.
I don't think Mr. Taylor will take very long. In fact, he may just be comfortable with answering questions on his evidence. I know he has indicated that he's a bit nervous about speaking. So,
All right, Mr. Taylor, we'll deal with you. My apologies to the team that was at the table. Please do come up.
Can you hear me?
Just bring that mic a little bit closer.
Okay.
I've been learning from the best all weekend.
How's that?
Great, thank you.
Great. My name's Chris Taylor and I'm from TDD.
Okay, now.
Just bear with me if I get a bit mumbly and I'm pretty nervous.
No, please do just relax. We're really keen to understand your perspective. So,
Okay. Thank
just
you.
in your own time.
My name is Chris Taylor. I'm a director of TDD Limited. My wife Antoinette and I own lot 1 DPS 61801, which is a 1 hectare property located at 474 Amakara Road. And we live on the site. We also operate a storage business from the site known as Amakara Self Storage. We have operated the storage business for approximately 16 years. Our storage business was established by way of a resource consent granted in 2006. The resource consent is limited in its duration and expires in 2026. Our land is zoned residential MDRZ under Plan Change 92, and we have supported this zoning through a separate submission on the plan change. Back in 2006, we applied for a land use consent for a storage business on the site. There was significant demand for this kind of facility due to urban intensification in Amakara that had commenced. We have operated a highly successful and well-run business on the site over the past 20 years. The council recommended decline on the consent at that time. The land was tagged in strategic plans for future residential use. We accepted the limited 20-year term to our consent, included as a condition of the granted consent following a notified resource consent hearing, as our intention was always to develop our land for residential purposes once it was rezoned residential. At page 9, the committee's consent decision stated, the committee noted that by limiting the life of the consent could allow the facility operation to be revisited in the future. Whilst the imposition of review conditions could be imposed to deal with any effects that may arise from the operation of the facility, it was determined by the committee that a ceiling be placed on the activity such that at the predetermined time, the applicant would need to reapply and the assessment at that time could have regard to the operative and or proposed plan requirements in place at that time and that of other strategic and policy documentation. For 15 years from 2006 until 2021, at no stage did the council contact us to discuss the purchase of our land for open space reserve land. However, in 2021, we received correspondence from the council that they would like to acquire our land for the purpose of an active reserve. We attended an open day and also contacted the council on a number of occasions to find out more about their plans for the land. We were particularly interested in finding out about the timing of the active reserve development and how this would affect our future at 474 Mokoroa Road and our long-term plans for residential development of the site. In particular, we were concerned about how it would affect our storage business. Decommissioning of the storage sheds would affect numerous locals who are lessees of the sheds and rely heavily on them. Since we became aware of the proposed designation over our land, we have made numerous efforts to consult and engage with the council. Following the notification of Plan Change 92 and the notice of requirement, at our request, we met with council staff on the 8th of March 2023 to discuss the designation and how the designation would impact on our future. We met in good faith and spoke with the council about our situation and our desire to work collaboratively with the council so that they could acquire our land through agreement. We discussed options such as the council purchasing our land outright and alternatives such as the relocation of our business to land owned by the council in the industrial zone in Amakoroa. It was agreed that we could progress an outcome with the council with a view to the council producing a voluntary compensation agreement under the Public Works Act. After our first meeting, I was initially comfortable that we would reach an agreement to provide certainty for us and to ensure that our reasonable costs were covered under the Public Works Act process. Council staff asked us to provide them with financial information relating to our business and its operations to help them with the evaluation of our land and business. We provided this confidential information to council staff on the 4th of May 2023. The council obtained a valuation for our land. I understand that they still have this, but we have never been provided with a copy. We engaged both an RMA lawyer and our planner to provide us help and guide us through the process. Our lawyer asked council to put in place a PWA process in regard to mutual exchange of valuations and for council to agree to pay for our reasonable costs to engage professional consultants. The council advised my lawyer and planner that it would not do so until it had decided what it was doing with our land, stating on the 30th of May 2023, before council proceeds any further, we need to finalise our planning and strategy for the land we need to acquire, noting there are a number of properties council needs to acquire. The funding/budgeting for the acquisitions also needs to be approved. Council is working through these issues as quickly as we can, but until this planning is finalised, it is too early for us to be entering into negotiations to acquire the land from Mr. Taylor. We will confirm matters such as costs, etc. in due course, as well as any evaluation process to be used. We confirm that any commercially sensitive information provided to us, such as financial and valuation reports, will be kept confidential, provided we may disclose these to our professional advisors, who will also keep such information confidential. We will come back to you once we're in a position to progress the purchase. Despite several follow-ups, my lawyer could not find out anything from council about their decision around PWA process or acquisition timing or strategy. We received only vague references around the finalising of the acquisition strategy and timing. I received no advice from council as to what the council's plans were for payment of evaluation or advice. As to council's lack of advice on timing of acquisition of our land, we have not been able to make any plans about our business or provide any advice to our customers about what is happening. On the 18th of August 2023, we finally received an email after constantly pressing the council for a response. The council stated that council has concluded that since development of the land is not immediately required, council intends to formally commence the acquisition process of your land between 2026 and 2028. A further comment in the email said, council will, however, consider any other proposal you may have ahead of the 2026 to 2028 timeline option, which may include an earlier acquisition of leaseback option, subject to a successful Plan Change 92 implementation and active reserve designation. I feel that our efforts to engage with the council have been a waste of time and that council has no real intention to proceed with a voluntary purchase of our land on suitable terms. The process has created significant stress and concern for us for the following reasons. Despite asking on numerous occasions what the plan was for the development of our site, we have never been given any master plans or plans which show the need for or the purpose of the reserve. Just last week, we received a plan by email which shows a master plan for the reserve. However, I understand that this is a concept plan only and has not been through any formal council approval process. I believe that there is no council-adopted reserve master plan developed for the site which shows the need for our land to be used. We now have a designation over our land with no certainty of when the council will proceed with the purchase of the land and the creation of the active reserve. The designation sterilises our ability to do anything further with our land. For example, once our land use consent expires, we may wish to apply for a new consent to extend the consent. It is unclear, based on the vague timing provided, if this would be contrary to the designation's purpose of a reserve. If council objected on that basis, we would be unable to create any income from our land. This outcome for us is completely unfair and it's unjust, particularly given that we have always said to the council that we would work with them on a collaborative basis in relation to the purchase of our land. With no certainty on the timing of the designation, no confirmed plan for the site nor the purchase of the land so that it can be developed for reserve, we have no choice but to oppose the designation. We will also need to apply to extend our business through another fixed term consent to allow us to continue to operate our business on the site. Rather than let our economic livelihood be wound down and have to wait until council takes another 20 years to sort its funding for purchase and development of our land for active reserves. Council strategy and need for this land should have been confirmed before a notice of requirement was imposed over our land. I have read the officer's report in relation to the notice of requirement, and the actual potential effects on us have not been assessed at all. In particular, there is no assessment on the social and economic effects on us of the designation. In our submission, we set out a number of matters which we request to be addressed by the council. These include, number one, the council consults with TDD Limited in relation to the timing and process for the acquisition of our land. Number two, that a master plan be prepared that shows the need for our land. Number three, that certainty is provided in relation to timeframes that will enable our investment decisions to be made in relation to the continued operation of our storage business. Number four, that the council commences the process of land acquisition and and discussions with us. We feel the consultation we have attempted has been a wasted effort and none of the other matters have been addressed through this process. The current notice of requirement effectively sterilises our land and does not enable us to continue with our existing business, creating significant stress, hardship and uncertainty for us. So I request that the notice of requirement be declined. Thank you. Yep. Yep.
Having said I learned my lesson, I clearly. But you sat through this morning and heard the council's comments in relation to their desire to work with you. Have you got any further feedback?
No.
So having heard that, that hasn't changed anything for you?
No.
Okay, that's fine.
All I heard was a lot of noise that didn't seem to have much behind it, to be honest.
Thank you. Any other questions from the panel?
It's not so much a question as an identification with your problems. Having in the past been involved with quite a lot of people in your position, I identify. However, it's beyond our powers to direct consultation or negotiation. But I do observe that there's been a large turnover of personnel at council. And all I can say is I hope they have heard your plea.
Thank you. Thank you.
Thank you, sir. Right. So just to be clear in my own mind, if the council had a proposal for you in terms of purchase of your property, and if you had some certainty in relation to your ongoing operation until they develop that site, are you open to the eventual conversion of that land into public park? Or are you still saying under no circumstance can that occur?
I'd have to think about that.
Yes, that's all right. I'm not trying to trap you anywhere. I'm just
Yeah.
trying to understand what you're thinking about. Thank you.
Obviously, we've lived in Amakara since 2020.
Yes.
It's a beautiful place to live, and we've
Yes.
got big concerns, for the way things develop in the future. Obviously, we need walkways, we need reserve land, we need places for kids to play, but it's got to be done the right way.
Yes.
And they've got to make an attempt to look after people that not just people who own the land, but I mean, we're cracking on in age now. I mean, I'm nearly 70 and my wife's nearly 80 and we're still going to work.
Yes.
So, we've got to consider ourselves as well.
Thank you, sir. Well, I think the council, they're here and they're talking, but they're also listening to what's being said today. So we can't speak for them. But as Commissioner Worthy has said, this is an opportunity to put some of those things right and perhaps start afresh. But that's for the council. We, in the meantime, will make our decision on the basis of your evidence. So thank you very much for that.
Thank you. Thank you.
Mr. Collier, how long do you think you're going to be?
No, sir, I wasn't intending to speak. I was just here to support
That's great.
Mr. Taylor.
Thank you.
But I can reiterate a couple of points that Mr. Taylor raised. And I was involved in obtaining the original resource consent back in 2006 for Mr. Taylor.
Yes.
So at that stage, the game fund was identified as the reserve area.
Yep.
Mr. Taylor's site was just identified effectively as future residential. And so one of the issues that Mr. Taylor faces is that his consent is about to expire and he will have to try and, if you like, reapply under a designation sitting over his land.
Yes.
I have turned my mind just to try and assist the committee around how that might work through in terms of potential conditions.
Yeah.
I haven't been able to land on anything because in my view, any conditions around the designation
which might, for example, require the requiring authority to ensure that affected landowners have the right to continue activities on their site as at the time of the decision of the designation, and have the ability to apply for further consents. That would effectively, in my view, need to be an OSIA condition offered by the requiring authority. So that's not an easy one to deal with. The second aspect really is in terms of the timing. And the horse is already bolted in many respects, because as you've seen from your site visit, there's a huge amount of development already underway. So I do have some concerns around this 15-year timeframe for the designation. My view is the council should be looking at actively planning and getting this reserve underway now, not in 15 years' time or 10 years' time. So I reiterate Ms. Barabicino's comments around a shorter term. The provision of this active reserve and open space kind of area needs to occur in conjunction with the development. Thank you. Those are just my two observations to try and help you, because it's obviously not an easy issue you're grappling with.
That's really helpful. Could we please ask you to not to do it now, but to turn your mind to the consenting issue, which you raised as the first matter, and provide the hearing with your thoughts in writing in relation to the way that these matters could be addressed to allow that consent to continue.
Yes, certainly happy to.
If it helps, can I just understand whether the council is happy to participate in that process, so there might be a joint position?
In terms of looking at a condition to go on the designation,
in terms of
specifically,
I think more broadly, the solution that provides for the ongoing operation of the consented storage facility through to the council undertaking activities at site. So, yeah.
yes, happy to continue exploring that. You have heard this morning from the witnesses around an openness to allow that happen
Yes.
until the land is required,
Yes.
and discussions around the leaseback options and things. So I think that's certainly all on the table.
We've heard that at the general level, so if it's able to be taken down a notch or two to, as Mr. Collier has talked about, an OSIA condition or whatever the instrument is, that, yes, I'm not going to be cheeky and talk about how district councils get their consents or put things on hold almost in perpetuity, but whatever the method is by which you get there, we'd like to hear that. Thank you. Right, thank you very much.
Thank you.
Thank you, Commissioners.
Thank you very much, Ms. Barabicino. Right, now we've got Mornay and Rachel Jacobs. Is that all right? That's fine. Yeah. Good morning. Good morning.
That one there.
Look, and if you'd like to all sit up there together, we're very happy with that. Thank you.
I also am not accustomed to public speaking and accustomed to the sort of forum, so excuse the waviness in my voice.
Again, just take your time, but also know that we've read everything you've written. So we have read it, and so what really helps us is to hear anything else you've observed this morning, any other thoughts you might want to add, or a summary of what you've written to us, because we've got it and we've seen it and we'll be going through it again.
Thank you. These are notes that my wife and I have taken all week to write.
Great.
Which add to what we've already put in our submission. To start with, my name's David Cummins, and along with my wife Trish, and under our company Rascal Holdings Limited, we own the land and building at 7 Prole Road.
Yes.
This was purchased in December 2016 after a long and exhaustive 18-month process involving the viewing and discounting of many properties. This was conditional purchase on approval being gained on the subdivision of the land. The land was subdivided from a larger block.
Yes.
And obtaining resource consent to operate an early childhood education centre on the site. Resource was granted in 2017, and in granting the resource consent, the council under section 104 assessment stated the proposed childcare centre on the site is considered an efficient use of property and will aid in improving the amenity of the Omokarawa Peninsula. Now that's a pretty strong sentence from the council at that time. The subject site is located on a local road and connects onto Omokarawa Road. The childcare centre is located in a strategic location to connect to the wider traffic network. Additionally, the upgrades to Omokarawa Road will provide pedestrian and cycling connections to the site, which will allow for alternative means of transportation to be taken. For the reasons discussed above, it is considered that the proposal is consistent with the relevant future urban zone objectives and the policies contained within the district plan. And go on to say, in having regards to the above matters, the proposal is considered to generate adverse effects which are no more than minor and acceptable in this environment. Taking this into account, it is considered that the childcare centre will be compatible with the existing environment. In addition, the proposal is consistent with objectives and policies of the operative district plan and the purposes and principles of Part 2 of the Resource Management Act 1991, and accordingly consent has been granted. Having received that resource consent, we went ahead and settled on the land with a view to building, and with a view to our planning our retirement and securing an income from the lease back to the childcare education centre. We went ahead with extensive renovations on the building and invested in excess of a further $250,000 in upgrading the facilities to meet council and Ministry of Education requirements. Given the investment, this was never intended as a short-term investment. A commercial investment on this scale would be expected to have a lifespan of 25 to 30 years minimum. However, just a very short 4 years or 6 years later, we find ourselves in an untenable position of having a property that is potentially unsaleable. Whilst we talk about 6 years, in actual fact, we've been dealing with this knowing the council intended to take the land under the Public Works Act since 2021. So that's only 4 years under a resource consent. I want to reiterate that we're only 6 years in. Why did the council ever grant that resource consent? Almost criminal, I would suggest. Our tenants, over the last 6 years, there's been an enormous amount of work and money gone into making this a highly sought after and regarded education facility that can only be described as an asset to the Omokarawa community. There are some 68 children that attend, and there is a 1.5 year wait list. Where will these children go? What makes the garden unique is the land, trees, outdoor space that makes it a home away from home. There are chickens, rabbits, veggie gardens for the kids, the children to play and learn. In saying that, it's not a big space in the scheme of things, of only approximately 1,400 square metres. This is an educational facility that sits opposite the education precinct and will feed directly into it. There is very limited land/buildings available in Omokarawa that will fit within the council requirements to replace this. You cannot have commercial access off Omokarawa Road, and I believe that's where they're going with Prole Road as well. In the proposed active reserve, the land that is present 7 Prole Road is turned into a car park and forms part of a future swimming pool complex. As we've heard from Ms. Barry Pacino, the cost of a swimming pool in today's money is $75 million plus. I'm sure that we'll see a light rail running in Auckland before we see a swimming pool complex in Omokaraha. Does the removal of an educational facility in what described in a future educational precinct fit the term efficient use as assessed under the resource consent process? I don't think so. In developing the plan for the proposed active reserve, the council has taken for granted that under the Public Works Act, they can require whatever land holdings they want. What an easy and simplistic view that is, whereas any other developer wishing to undertake such development is constricted by the ability to purchase by negotiation and or agreement and has to work with what they have been able to purchase or acquire. The council's had a singular focus on this reserve. The council has, in this instance, in our view, failed to consider the existing use of the land, and as I previously said, has been described as an efficient use of the land. That there may be in some distant future time, an enormous amount of money forthcoming to build a swimming complex and car park does not make sense to issue a notice of requirement and force a compulsory acquisition of number 7 Prole Road, which is 1,400 square metres of land and is not an insurmountable issue for any decent town planner to work around. Have the council planners even considered the option to work around this facility at all? Throughout the process, as submitted by the previous submitters, the council has been less than honest and forthcoming with their following correct procedures, and we get the feeling that it's all been a lip service attempt at ticking the boxes before this hearing. During this process of ticking the boxes, the council contacted us to show an alternative property as a potential site swap. Both my wife and I, Rachel and Mornay as the lessors, and 2 members of the council attended a meeting at 29 Prole Road. At this meeting, which the tenants were completely unaware of was happening, it became very apparent the council did not have ownership of the property, but they were completely unaware of what they were offering. No idea of land size or building size, what was happening there. To us, it was just a complete waste of time and stressful to say the least, and just reiterates the feeling of lip service being paid by the council. In Annalie's statement of evidence, she advises under section 22, as at the date of this statement of evidence, the council has not had any response from any landowners to this email. This is in fact not quite correct, in so much as to at our meeting to view the replacement property, we asked the council to go away and put together a scenario of them buying us out and the centre being leased back. Just what would that look like? All we received was another copy of the email as the same as Mr. Taylor, stating they were not in a position at that point in time to further the purchase. We felt that we didn't need to respond to that email as we'd already asked the question to which there has been no response. Further that, how can the council purchase the land and then potentially just offer it back on a 6 or 7 year lease with no buyout of the business at the end? At the end of the day, the real question is, has the council and its planner given consideration to the existing use, one that they've previously described as an efficient use of the land and one that contributes to the local community and one that sits in the educational precinct? In a community such as ours at Omokaraha, we feel that the council has an enormous responsibility to endeavour to relocate what is a valuable asset such as the garden early childhood centre, not just write a cheque and build a car park. The ability to just move the centre is not something that can happen overnight, and there are a number of hoops that need to be jumped through just to get it to the planning stage. There is a lot of expense involved in that, and who's going to pay for that? In discussion paper attached to Jeff Cannon's statement of evidence, Tracy Miller talks of the level of service that the council must provide. And she goes on to say the structure plan anticipates 2,400, that's 2,400 additional dwellings, and how that additional demand on the current facilities is unlikely to be met by the existing Omokoroa sports ground. Whilst totally agreeing with this observation, it would be naive to suggest that the existing educational facilities available in Omokoroa would be adequate, let alone the removal of one centre. What we would like from this hearing is for the Commission to ask the Council to reassess the latest proposed plan with its planners and redraw the concept plan to work with and around the existing educational facility that is 7 Prole Road, and decline the notice of requirement. Alternatively, at the Council's expense, provide a like-for-like centre within the Omokoroa Peninsula so that the community can continue to have the excellent educational facilities that it has now. Thank you.
Thank you very much. Thanks for your contribution. Any questions from the panel? Yeah, look, I would just simply be asking you the same questions I'd asked the last submitter. The thing I do want to do is acknowledge, and it is maybe meaningless, just acknowledge the enormous stress that's associated with these processes. And it's a process that you're in for years. It's not minutes or weeks. It's not easy, and we see it regularly. So same thing to the council. We hope that they are hearing what you're saying and thinking about at least the options they can contribute to in a constructive way.
Yep.
Thank you.
Thank you.
Kia ora koutou katoa, ko Rachel toku ingoa, ko Tauranga Moana oku tipuna, kei te noho oki Omokoroa. Tēnā koutou, tēnā koutou, tēnā koutou katoa. I want to start by sharing our vision to support tamariki to develop a lifelong passion for learning that fosters self-worth, develops independence, and nurtures the innovators and thinkers of tomorrow. We will achieve this through building respectful and trusting partnerships with tamariki and whānau, and by recognising the uniqueness every whānau brings to the garden. I'm terrified of public speaking, but today my husband and I have been blessed with 10 whole minutes to defend our livelihood, our passion, our purpose, our commitment to true quality education in the community of Omokoroa. Please keep that word education in the forefront of your mind as I unwrap our story for you.
Hallo, mijn naam is Morney. Ek is van Suid-Afrika. Ek wil net baie dankie sê dat julle ons die geleentheid gee om hier so te wees. Baie dankie daarvoor.
I start with a sad story, not for sympathy votes, because this news ended with a fantastic journey. Morney was blessed with cancer many years ago. I say blessed because he had an operation, had chemo, and got better, job done. We were the lucky ones. We also had life insurance and received payout. We had options now. What can we do for our whānau and for future generations? Somehow we landed at developing and opening our own education facility for tamariki up to 6 years old. I am a teacher, my husband in business management, and so the journey began. We literally put our whole life's savings, including that cancer payout and the profit from selling our first home, into developing the centre. A centre based on a vision for quality education, there's that word again, with open green spaces for tamariki, space for chickens and bunnies, space for growing vegetables and swan plants, for the wonderment of watching butterflies hatch. A space to catch rainwater that forms giant creeks in the sand. A space for a mud pit to ensure parents never have a clean child to pick up at the end of the day. A space where tamariki can truly be the leaders in their learning. They can explore, discover, and learn through play, which is the tried and tested best way for tamariki to learn. But in the scheme of things, and the council's very large parcel of land, this is all achieved on a mere 1,400 square metres.
The Garden Early Childhood Centre is located at 7 Pearl Road. This is not just a business that can up and relocate anywhere else. This is an education facility purposely and thoughtfully designed and built for 68 tamariki at present, or close to 150 tamariki over the past few years. Currently situated directly across the road from another future educational facility for tamariki 5 years to 18 years. It just makes sense for us to be where we are. And the Western Bay Plenary Council recognized our importance and position in the community just 6 years ago, clearly stating in the resource consent that it granted to us in 2017, saying that, and you've heard this before, the proposed childcare centre in the subject site is considered an efficient use of property and will aid in improving the amenity of the Makaurua community. The childcare centre is located within a strategic location to connect into a wider traffic network. Additionally, the upgrades to a Makaurua road will provide pedestrian and cycling connections to the site, which will allow for alternative means of transport to be taken. It goes on to outline a number of points and then summarizes with, for this reason discussed above, it is considered that the proposal is consistent with relevant future urban objectives and policies contained within the district plan. In addition, the proposal is consistent with the objectives and policies of the operational district plan and the purpose and principles of Part 2 of the Resource Management Act 1991, and accordingly, consent has been granted. These are very clear statements, gave us the reassurance we needed to pour our hearts, our souls, and quite literally our blood and tears into our new development. A business that could serve our community with strong moral ethics and that we could be proud of. A business that would see us through our retirement and could be sold to the next kaitiaki, sorry, of the future generations.
Let's get back to our location, directly across the land from that the Ministry of Education currently owns and is developing a new school set for completion around 2026. This now gives us the ability to seamlessly coordinate and collaborate with schools at all levels to prepare and transition our 4-year-olds to move into primary with the knowledge they need to succeed, knowledge that our teachers have gathered from collaborative discussions with primary teachers. We have the opportunity to share learning experiences with the primary school, the opportunity to share learning experiences with the high school, for high school students to visit us, spend time with us when making decisions about future career opportunities. The high school may have an in-house ECE module, much like Bethlehem College or Tauranga Girls, where they regularly spend work experience days with us, or they invite groups of tamariki over to participate in a program they have developed and will facilitate to further their knowledge and understanding of ECE. A concept we often use in our setting that would be beautifully extended across the road into primary and high school is the tuakana-taina relationship, a concept from Te Ao Māori that refers to the relationship between an older person and a younger person. Within teaching and learning contexts, this can take a variety of forms, such as peer-to-peer, younger to older, older to younger, or able to less able. To finish up with the key points we need to emphasise, we are an education facility located directly across the road from a future education facility. We serve the community of Omukaroa with a very unique philosophy that is not currently provided by any other early childhood centre in Omukaroa. Whānau choose us for our philosophy, our reputation, our teachers, our quality education, our commitment to our values and ethics. We have a wait list of more than a year, with families enrolling their unborn infants with us to secure a placement. We are currently turning down enrolments on a weekly basis, so Omakoroa clearly needs our service. With the predicted growth from the current 2,462 dwellings to 4,147 dwellings by 2030, there is a clear need for our service, as well as potentially any new centres that may be developed over the next 7 years. The garden is committed to our community. We are involved with the local primary school through the PTA. We provide sponsorship for local events. Morna is a volunteer fireman and is able to serve our community through his flexible working arrangements at the garden. We are well established to serve our community. We have literally put our life savings into developing the centre, thinking we would have 25 years, have a 25-year return on that investment, and then be able to sell a viable business to fund our retirement. Therefore, we are left with absolutely nothing at present to relocate this business elsewhere. We employ 15 local teachers. Their livelihoods are uncertain. This is affecting our business now, with parents asking questions of uncertainty around their children's education. We see two viable solutions moving forward. Number one, the council planners take our very small 1,400 square metres into consideration when designing this future development and leave it right where it is, perfectly placed across the road from higher education. Surely the education of our future generation, the little people that will become our nurses, inventors, salespeople, farmers, lawyers, doctors, teachers, scientists, or care for us in our old age, are more important and valuable to Omakoroa than a car park. I'm pretty sure the cost involved will be significantly less for the council too. Or number two, the council finds suitable land close by and provide a true like-for-like transfer. A fully developed nature-based early childhood centre on 1,400 square metres with a sandpit, mud pit, chicken coop, bike track, veggie garden, grass, trees, and it's Ministry of Education compliant. And we can continue doing what we do best for Tamariki of Omakoroa, and the council can develop their car park at 7 Pearl Road. Tēnā koutou, tēnā koutou, tēnā koutou katoa.
Now, I know you felt constrained to 10 minutes there, but is there anything else that you want to add that you feel that time frame might have constrained you to saying?
No, I don't think so. I think I got it all out there.
That's very useful. Thank you, both of you. Can I ask the commissioners if there are any questions? Commissioner Withing.
First of all, I just want to congratulate you landowners for making very succinct, direct and helpful submissions. Some of the experts that appear before us who do this a lot could well learn from you in the way that presentations are made, so thank you very much. Second thing I'd like to say is that the notice of requirement covers a lot of land and multiple ownership, and the need for that land has been established by evidence from the council, but not all of it. And so the timing is very relevant. So having been a person who has been involved in these matters in the past, I would just make the suggestion, if I may, that you have legal advice, you have planning advice, and as I mentioned earlier, the personnel at council has changed quite radically over recent years. And I would just offer the suggestion to you that you enter negotiations with the council as to the extent of the requirement and the timing for it and how that affects you and your businesses. So I have a great deal of sympathy for your points of view. However, we as a panel have very limited ability to do anything for you other than make those suggestions that I've just made.
Thank you very much. Your presentation was excellent. Your evidence is really clear, both for the two parties and collectively. Same thing again, just to acknowledge the situation you're in. That's not worth much to you, but we are going to spend a considerable amount of time just thinking about the way through this, and we don't have a decision in our minds. So your contribution is quite valuable. Thank you.
Thank you.
Kia ora. I think we have now heard from all submitters. Can I just be clear that that's the case? We've got correspondence there from Annette Giles that's been circulated to us this morning. Can I just be clear that the council team have got that correspondence as well? So she was going to attend and speak to her submission, but is unavailable, and in the event has sent a note to council articulating her view on the matters. So you've got that?
Yes, I believe we do.
Thank you very much. So again, we're reading that. We've got it for the processes we're involved in. There are any number of submitters who have not been in front of us for good reason, but their submissions stand. We're reading through them and they're part of the decision-making process. So thank you. So we are going to adjourn the hearing, take the lunch break, and then when we're coming back, we're going to hear from the Council's reporting officer, the Retirement Villages Association, and then have right of reply from Council. Is that as you understand it?
Yes.
Thank you. And to the submitter team, thank you again for your contribution. Mr. Hinchy, Mr. Brown, thanks for your patience. You can hear us all right at your end?
Yes, I can. Can you hear me okay?
Right. Mr. Hinchy, I can't hear you talking at your end.
Can you hear me, Commissioners?
Yes, we can. Thanks, Mr. Brown.
Thank you.
This is what happens when Chapman Tripp doesn't pay its power bill.
That's right.
No. So we've clearly got the connection to you, Mr. Brown. We'll just
I can continue if you like.
Well, look, I think we might do that because we were hearing from you. We'll just get the team to message back to Luke, but we were hearing from you today anyway. So this, I think, was your opportunity more so than Luke's. Thank you.
That's great. Thank you. Well, firstly, I'd like to note that the rest of the team's presentations were heard yesterday. So, so I thank the panel for accommodating a separate session for me today. My full name's Matthew Glenn Brown. I'm the General Manager, Development NZ for Ryman Healthcare. I've held this role since March 2020. I've prepared this statement to provide a brief overview of Ryman's interests in Plan Change 92 to the proposed Western Bay of Plenty District Plan. I do not propose to repeat my evidence. However, I reiterate that there is a major need for comprehensive care retirement villages in the Western Bay of Plenty. Development of new villages will be needed to meet the longer term shortfall. Ryman does not currently have a retirement village in the Western Bay of Plenty. We are, however, actively looking to invest in the district so that we can provide the highest quality housing and care for Western Bay of Plenty's older residents. Ryman is very encouraged by the direction of the enabling housing legislation. Planning controls are a significant factor impacting the speed and efficiency of building new homes for older people. Clear planning provisions allow us to invest with much greater certainty, and we can design villages and use scarce land more efficiently. I note that land of appropriate size and location for our villages is very difficult to find. Providing more opportunities for density and height will increase our options to build new villages in areas where they do not currently exist. Conversely, planning provisions that are unclear or do not properly provide for retirement villages cause major delays. Examples of key issues include extensive consent assessments, Section 92 requests, and public notification processes. Consent processes can vary from around 4 to 6 months for non-notified consent applications to over 2 years for a notified consent application, and that's from commencement of application processing. Put in context, for many older people desperately needing appropriate comfort and care at a stage of their lives when they are most in need, an extra year or two in a retirement village can be very significant. I was pleased to see the council officer's acknowledgement that retirement housing is an important component of the district's communities and should be provided for in the district plan. However, I was disappointed to find that the officer's report as a whole recommends rejecting the majority of the RVA and Ryman's submission points. It appears that the council officer has misunderstood the unique nature of our villages' operational and functional requirements and residents' needs. I consider that a more comprehensive suite of provisions for retirement villages, as proposed by Ms. Williams, will better assist us in planning for and building new villages in the district. Our team have developed these planning provisions based on many years of experience with consenting retirement villages. In addition, it is important that PC 92 addresses some of the key consenting challenges that Ryman currently faces. And I'll just set out 4 bullet points on that. So, including the lack of provision for the day-to-day needs of older residents and overly restrictive or complex urban design controls. Retirement villages have a unique functional and operational requirements due to the day-to-day needs of residents that council officers processing consent applications often do not appreciate. For example, a large format building is generally required to accommodate care rooms and community amenities. Unit types and amenities are often very specialist in nature to cater for resident needs and mobility and health constraints. Ryman is best placed to design villages that provide for these needs and has a long and positive track record of doing so. Secondly, the lack of emphasis on positive effects. Our villages generate substantial social and economic benefits. These benefits are both through housing and caring for older people and generating jobs and economic activity in local communities during construction and operational phases. Positive effects can be overlooked in the consent processes. Thirdly, the need to enable efficient use of suitable sites. Sites that are appropriate for retirement villages are rare due to size and locational requirements. Western Bay of Plenty is no exception. We can build villages in both greenfield and brownfield sites in residential and appropriate commercial areas where they are available and where the planning context enables their use. We encourage more responsive and flexible provisions, which will give us more access to more potential sites. And fourthly, notification issues with village consent applications. Notification processes create significant consent hurdles as they lead to lengthy delays, costs, and uncertainties, often as a result of immaterial or irrelevant arguments being raised. If retirement villages are given the same treatment as other multi-unit residential activities in relation to notification, we will have much greater confidence when designing our villages and in terms of the timeframes to complete the consent processes and commence building. On the topic of financial contributions, Ryman has no issue paying council contributions for the impacts of its villages on council services. That said, these changes need to account for the lower demand profile associated with retirement villages. Due to the age and frailty of our residents and the on-site amenities and services we provide, our villages generate very low impacts on council services. Over time, we have invested significantly in independent surveys and research to establish this fact. Our work included a successful challenge to contributions for many of our villages in Auckland via a Local Government Act objection process some years ago. Further, any financial contribution provisions in the district plan need to be clear and certain so we can assess development feasibility with confidence. Ultimately, the changes Ryman seeks to PC 92 are intended to improve and streamline consent processes to ensure the efficient delivery of housing for older people. However, we are not seeking to move away from an effects management process or approach. The provisions we are putting forward largely seek consistent treatment to other multi-unit residential developments. I understand that the provisions focus on the key effects that potentially arise, including positive effects. Ryman agrees with and supports the key outcomes sought by the RVA, as set out yesterday by Mr. Collins, Mr. Hinchy, Professor Kerse, and Ms. Williams. Thank you. Any questions?
Well, just to note, I can hear you now. It was good. It was my mic, I think.
Thank you. We've just got to the end of Mr. Brown's presentation, and we're taking questions from the panel if there are any.
Yeah, I heard all of Mr. Brown's presentation. Thank you.
No, there are no questions from us. It's not because we're not interested, Mr. Brown, but we received extensive evidence and advocacy in the last few days from the sector, and it's been really helpful. And it's important that I think it's one of the fundamental issues that we're going to be addressing in our decision-making process. So we thank you for your contribution.
Okay, no, thank you for hearing me. That's great. Thank you.
Thank you.
Thank you, Commissioners.
Thank you very much.
Thanks, Commissioner.
Okay.
Oh, just before you go, Mr. Hinchy, we've got the memorandum there regarding a site visit.
Oh,
the
yes.
Commissioners will have a discussion in relation to that and provide feedback.
Okay.
It'll probably be early next week now.
Sounds good.
Thank you very much.
Thank you. Have a nice weekend.
You too.
See ya.
Okay. Right, I think we are into the 42A officers report. Is that where we got to? I've
think
lost
so.
track a little bit today. I'm sorry about that. We're coming and going on things.
Thank you, Commissioner. Just to start with, just to echo some of the sentiment today, that just to acknowledge the submitters and sympathise with their situation, and that it's unfortunate how the RMA creates these often emotionally charged situations. However, that said, as an NOR application, there is a requirement to assess this under the RMA. My section 42A includes my assessment of that, and I have not heard any issues today that fundamentally change that recommendation, which is to confirm the designation subject to conditions. That said, I would just like to cover several points. Firstly, the NOR application and proposed designation is a product of long-term planning for this area for urban growth, and has been, I suppose, an integrated part of that.
Yeah, I'll just get you to put that mic a little bit closer so
Yep,
we can
sorry,
hear
I'll
you a bit
sit
better.
closer.
Thank you.
The purpose of the designation as well is to signal intent of land use to the community. And there are RMA and PWA processes that follow on from this. So assuming the designation is confirmed, I would expect the onus to be on the council to then engage with the landowners and follow up on those processes, which include compensation and the like. In terms of some of the comments on behalf of TDD, I don't share the view that the designation will sterilise the land, given there are specific provisions under the RMA that recognise the ability to continue to use land that are subject to a designation, albeit I do acknowledge that that is subject to agreement with the requiring authority. And in terms of the social and economic effects raised by Mr. Taylor, I would have thought, and I consider that these are already in play through the time constraints that are applied to his resource consent and the uncertainty that follows on from that. In terms of 7 Prol Road, just to acknowledge that it's unfortunate how there was no time constraint put on that resource consent process. However, that doesn't change the fact that this notice of requirement is required to be assessed on its merits. In drafting the Section 42A report, I did question Mr. Hexel at the time on the options for the Early Learning Centre to remain on site. And at that time, I was advised that is an option that was not being considered. However, I would just note that that option isn't off the table if the council were minded to reconsider that position. And just lastly, on the commissioner conditions, I'm certainly open to suggested amendments. However, would appreciate some more guidance from the commissioners on this. I'm not quite clear that I've maybe understood some of the concerns correctly, but as I understand it, two of the key ones that stand out for me are a condition about requiring an outline plan process and also ensuring involvement with Pirarako, which is not just about earthworks and perhaps encompasses some other components of an outline plan process. Kia ora.
Thank you very much. Questions from the panel?
To cut to the chase on the preschool, I'm unconvinced that their land is required within the NOR. What's your view?
Well, the plan that I've been given and that you've got in front of you shows that that land would be required as part of the NOR, albeit for parking purposes. But I do note that that is a concept plan. I don't think it's set in stone. So again, I would defer to council on the assumption that the designation is confirmed, that they have the option open to negotiate with the Learning Centre directly. But as it stands, I don't see why that land wouldn't be required based on the plans that I've been provided.
Thank you. I'm grateful that you have an open mind on the subject because I personally cannot see why they can't be worked around. My second issue is timing. And I certainly don't have a view, but I would hope that the negotiations with the landowners will include serious discussion about timing and how that reflects on the NOR conditions. Any thoughts from you?
Again, open to reconsidering the condition at the moment, which is for 15 years. That is obviously a long time frame, and some of us might not be planners by that stage. But yeah, again, my view on that is that, again, assuming the designation is confirmed, then the onus is on council to then start those processes and start those negotiations. So in that context, is 15 years perhaps overly generous? I don't know, but these things do take time. So whatever the time constraint or time condition is, just needs to acknowledge that there is a public process that sits behind this around funding and allocation of funding that is not something that happens as quickly as it would in the commercial world. And there's other things to factor in there.
I would hope as part of those discussions that the possibility of timing, different timing to different parts of the NOR might be considered.
So look, the panel is going to have a bit of a think about the process that allows us to have further engagement on the conditions. And yeah, it's likely to be early next week that we're kind of coming back and providing feedback on that. Look, in relation, sorry, I went straight past you. Yeah, sorry, Pia. In relation to the Taylor's consent, we've had some feedback from council. Can you just talk a little bit more about what you think it would look like to keep the operation live in terms of consenting, consent renewal and the like, through to the period where council initiates the physical works at site?
Yeah, these things are inevitably tricky, I suppose, in terms of how they get managed out. Obviously, the time constraint on that consent when it expires requires an RMA process to be followed. So I suppose in terms of statutes, you're bound by that as the decision maker. But that doesn't take away from the fact that there may be some opportunities for maybe some sort of MOU between the council and the consent holder, possibly, if that was considered appropriate. I'm just conscious that there's inevitably legal issues that just need to be considered when thinking about how these things play out. So I would probably defer to council on that, but I don't see why there couldn't be opportunities explored around how Mr. Taylor and TDD can continue operating on that site once the consent expires.
Yes, because I'm conscious that the expectation on expiry was it was, tell me if I've got this wrong, but it was available for housing. That was the expectation when consent was granted.
I don't know the specific history behind that. I'm sorry, so I'd have to defer to someone that does. But yes, at the time that consent was granted, I suppose there was a lack of clarity, if you like, around what this land would be used for in the future. At the time, I think it was just zoned future urban and put in a holding pattern. Obviously, there's been some significant legislative changes since then, which I guess would need to be factored in to any decision around how that operation continues on the site.
Can someone from the council clarify that for me? So when consent was granted, what was the expectation for that future land use at expiry?
In my actual evidence, I actually read out the condition,
Yes.
and they actually said the reasons for it. It did not state residential, it said strategic. And just to give some more context, if you refer back to the PC 92 application document in section 32, there's a whole series of the various structure plans that have been prepared over time. On that site, you'll see there's been multiple different options put out, which has included mainly commercial, schools, reserves, and sometimes housing. So it's been it's always, obviously for locations, a strategic area. So it's been subject to this whole process of strategic thinking on what is the appropriate zone in there. So there's nothing in the consent that I can see or anything else that states it's going to be used for housing.
Yes. But just to repeat what we talked about this morning, in the event that Plan Change 92 is supported, the underlying zoning will be medium density housing.
Correct.
Right. Thank you. Thank you very much. Right. Where does this take us now?
I'm happy to do a brief oral reply on the notice of requirement now, and then there's perhaps a wrap-up matter on Plan Change 92.
That would be great, thank you, if we can do that.
There's three matters that I want to cover. Respond to Ms. Garibachino's submissions, some comments on the PWA acquisition side of things and conditions. But if you're happy before I do that, just in response to Commissioner Withy's question around being unconvinced about the childcare land being required for the notice of requirement, I think it might be useful to hear some comments from Mr. Hextall, if you're happy on that point.
Oh, here we are. Yep.
Thank you. Just on that matter, probably because we had the plan back, but as you saw on the plan, the underpass is a key component of the urbanisation of that area, and that comes out exactly through where their subject site is. So there's that part of it. The other second one is part of the...
Mr. Hextall, I just need to check. That's a line on a map for a concept, isn't it? It's not fixed in space.
It's part of the Pole Road urbanisation project that's currently...
It could be 50 metres in either direction, couldn't it? Oh, the reason I'm saying it like this is I've heard your officers talk about having an open mind to resolution of these issues with the parties. And what I'm hearing you say is, for every other purpose, this is a concept, but for this purpose, it's fixed. So
yes.
Correct me if I'm wrong.
This is part of the Pole Road urbanisation project. So as a component of that, that comes through to the site. So Pole Road, the access is again closed, and that new road you see is the first access into that area. So it's basically a safety issue. So that the access that goes into the childcare centre at the moment will no longer be there.
Right.
So it's quite fundamental in how it's, if you'll see already it's quite a slope. Even with the improvements to the road, it's still a situation where you do not want access coming on in that area. So as part of that project, that is all, I guess it all combines to make the possibility of keeping any of that sort of operation there.
So it couldn't come via new road?
In terms of access, but then you're going to have issues being right in the middle of a reserve area. So you have a very strange scenario of, are you talking about being part of the reserve or as a...
Well, yes, potentially. I heard a witness this morning say that these playing fields get used for up to 20 hours per week, and there's a lot more hours in a week than that. And we've heard that the school will be over there using it, and we've heard that there's an intimate relationship between childcare facilities of this type and the school over the other side. So frankly, I'm at a loss to see why these things couldn't be considered for integration.
Perhaps I'll get Mr. Watson or Mr. Cowan to explain some of the scenarios you have with the Reserves Act and those kind of operations, because they're probably best positioned.
Mr. Chair, just first of all, just to clarify, the 20 hours is it's the turf's ability to handle play and training.
Yes.
So people do use the park more than 20 hours a week.
Oh, absolutely.
Yeah. Sorry,
Your evidence was very helpful in that regard. I'm just saying that there's a lot of hours in a day and there's a lot of space in that 10 hectares for designing these sorts of features.
It's a real attribute to any park to have a really safe crossing, particularly for the school across the road.
Yes.
My understanding is that roading project has gone to some lengths to ensure an underpass at that point of the grade where the road changes in height and there's a school across the road so that people use it.
Yes.
So they don't take shortcuts
So
somewhere
where the
else.
dotted arrow is now.
There we go. Yep. That's it. That's the rationale behind it. And to go to the midpoint of the reserve stops shortcuts and all those things that kids do.
Yeah.
That's why it's there. In terms of the school's use of the reserve, the school's not there obviously, but typically we know schools to be power users of parks next door. And again, it's purely a safety thing which the engineers have followed right through to this construction phase.
Have they? So that dotted line that we see on the map, is there something that council could provide us to show the engineering work that's been put into having it at that point versus 10 metres in either direction or 20 metres in either direction?
Yeah, I'm sure we can get information for you, sir.
That would be helpful to see that. And then I guess the other part of it is, I don't think anyone on the panel is suggesting that the sort of facility we're talking about or we've had put by Submit today has to go at that spot at all. So in the same way you've got lots of conceptual thinking within that site.
Yeah, we've been really, I guess, clear to say it's a concept.
Yes.
So it backs what you might have, but we've still got to do all those things we talked about.
Yes. And that's really helpful. And others have tried to diminish that. Well, I don't think we're trying to do that at all. The question is, could that concept include early childhood care?
I can speak from some experience and I'll pass it to Peter Watson. In terms of the relationship with those sorts of facilities and the Reserves Act, it's not an easy one.
No.
For example, recently, and I'm going to mention the neighbouring council again, sorry. Tauranga City have recently gone to some lengths to get rid of, move, the Blake Park kindergarten from Blake Park through mutual compatibility reasons. So it's suitable for neither party. The whole thing of a public place, meaning anyone can be there, and a childcare centre being in a park, all those things with the fit for it is often quite fraught. So invariably, I've been on the receiving end as a manager from childcare centres, kindergartens and play centres on parks that haven't enjoyed the experience. They prefer to be somewhere else.
Yeah.
Add to that, the commercial relationship on a reserve is a tricky one. And even if it's within, it's tough on the other people to transact that business typically when they're surrounded by public park.
Is that truly the case when most swimming pool complexes in this country sitting on public land are administered and run by private operations?
No, they're not.
I'm familiar with lots of aquatic centres that are run by private companies on behalf of councils.
On behalf
or
of council,
holding
but they don't
companies.
own it. So there's a difference.
Okay.
Big difference. So most public facilities, most public pools are that, but to your point, they are run by a third party or a contractor under a commercial
Yes.
relationship, often where the revenue is split and returns partially to the community, and the council sets the fees and charges. It's one of those sorts of relationships. The slight difference with childcare centres on parks is they do have a different financial model. They're there to make money that the community doesn't necessarily get a return. It's not a level of service of council to enter the business of childcare to take up some profit from it where there's rate revenue at play to run the operation. It's the difference with pools, where the pool is wholly on the public land. If the childcare centre is a lessee, that's an interesting scenario. And I'm not sure if that's what you're suggesting or if what you're suggesting is the land is apportioned around it.
No.
Both of those are quite different.
I don't think we're suggesting anything other than hearing council commit to thinking about the way that it might be able to engage with the opportunity for early childhood care at that site or in close proximity to it. This is
To assist you, I think normally when a park is approached to assist with this type of commercial activity, I think we've raised it this morning, is you would work with that person to look at all the options as we're obliged to. So we would go through a business case setting with those people to help them to look at all the other possibilities, including public land parks, where it might be hard for them to operate on. So,
Yes.
Yeah.
Yes.
But I think the intention is there to work with people. Also to confirm, most years, a council parks department will be approached by people who really like the park to operate on because it suits them.
Oh yeah, that's right.
It's an attractive place, and like a pool is a good place to put a pool because people might be going to the park as well.
Yes.
It's quite a tough road because the Reserves Act and the nature of those public places doesn't make that an easy fit all the time. And the strategic reaction to that is to say, well, we've got policies to enable and to help people, but it may not be your only option. So I think I'm trying to say people would get assistance in that regard, as we're suggesting, I think.
Yes.
Listening and working with folks and not just saying you can't do it here. It's quite opposite to that.
Yes. So I think the question we're going to ask you is, because what council is doing is transferring uncertainty onto these parties, and you know it, and you work with people like this all the time, and there's no question council's working in good faith, but these are community stakeholders that are in a dreadful space right now. So I'm interested in what it looks like for council to engage, not necessarily around delivering an outcome, but what does it look like in the next few weeks or few months for these people? And you don't have to answer that right now, but it would be really good to hear that, so that there perhaps is something for them from this hearing process, which has caused, a great deal of distress.
I would add just one more final comment. I have been through this very similar process with Western Bay myself, actually, in terms of the Public Works Act.
Yes.
I've been on the receiving end. I think I can speak to that with some authority.
Yes.
But, I would rather do that with Western Bay than most other councils I work for as a consultant.
Yes.
I say not in jest. I was treated very respectfully. It was an expensive process for Western Bay. I'm not saying that because I'm sitting at the table of the applicant, but I found that to be a process which moved with alacrity, and we reached a really good outcome.
Yes.
So I guess I can speak from experience. And I lived in Prole Road.
That's really
so
good
the
to
same
hear.
road as
Yeah.
the people. Yeah. So I felt nothing but empathy, and we had a very similar situation, but it was Public Works Act, it was the real deal.
Yes.
The way that was handled was per statute, every option's available, we were wrapped around and so forth. I would have a lot of confidence that the submitters this morning will be treated the same way.
Look, and I think our experience of this week with Western Bay of Plenty staff is, there's every reason to share that view. It's, they're very respectful, even in spite of stress parties have been feeling. They have reflected really favourably on the team here. It's good to see, and as you say, it's contrary to the experience you have elsewhere. But I'm just thinking about what Mr. Danby is saying in his role, and I think if I was a submitter hearing that, I think what he just told me to do was to lawyer up and planner up to pretty unfavourable outcomes. No one wants to have to hire a planner if they can at all sort of help it. So I'm interested in hearing from council what that looks like in the next wee while, if that's right. And we might produce some kind of, I don't think we want to do more directions, but we'll have a bit of a think over the weekend and come back to you. And just to say, your evidence, both of you this morning, was incredibly helpful to us in that regard. Your kind of honesty about what you've done and also what's not been done, and also the opportunities for Parks and Rec in this part of the world is hugely useful. Thank you very much. Sorry.
That's okay. I think this will be fairly brief. So just responding to Ms. Barry Pacino, her arguments this morning, which I understood to be coming to the issue challenging the size of the land that is sought to be covered by the notice of requirement. And Ms. Barry Pacino opened by talking about the panel having a lack of credible evidence and criticising the evidence provided this morning verbally. And then with respect, I think went on to do the same thing herself in terms of the evidence around future society, with cricket being out the door and table tennis. But in my submission, you do have robust expert evidence from Mr. Canham on the need for the active reserve to support the growth, the shortfall, the existing shortfall, the level of service. And when you read his written evidence again, the reports he relies on are based on the Kaimai ward, so it is servicing the Omokoroa and the Kaimai ward community. There's a need for the 10 hectares to do that. And then we heard about the wider sub-region and wider issues as well. In terms of the matters raised by the submitters, I think in opening I acknowledged those submitters, and unfortunately the concerns are not unique. They are not unique in these processes. I would say that the council is here and has heard those submitters and the panel's concerns, and obviously the evidence from council is that it is open, the door is open to those discussions, particularly around commencing discussions, leaseback options. And I've heard Commissioner with these comments around different timing for different parties, which is certainly something that was in the council's evidence, and the properties do need to be treated on a case-by-case basis. In terms of the relevance to the matters before you, Ms. Barry Pacino's submissions acknowledge that the PWA matters are outside the scope of this panel. But if it provides any comfort, I would say in terms of the submitters we heard today, issues such as holding a resource consent to operate a childcare facility are relevant to under the Public Works Act in terms of value. Owners of land are entitled to market value, and the regime in the Public Works Act is to provide full compensation to parties. So while that may not help you, that is what that regime is set up for. Turning to conditions, we have been looking at the wording of conditions, but most importantly perhaps is the lapse date. So the requiring authority recognises the 15-year lapse date provides uncertainty for those parties. And in light of the evidence that the active reserve may be needed earlier than it had been planned, the requiring authority is proposing to reduce that to 10 years. With the 10 years still being needed, we've got evidence around the funding available for acquisition of the land, but then there's still the process for the design and construction. And as I think Mr. Danby acknowledged, there's certain further public consultation, LTP processes to put that in place, and the 10 years is required just to ensure the requiring authority has the time to do that properly. I think the drafting is sitting here at the moment, but at a high level, the other changes proposed to the conditions to picking up on Commissioner Main's comment around the outline plan process, making it more explicit in the conditions. Draft condition 2 does talk about the separate outline plan process, but I think perhaps referring to the section in the Act and making it very clear. And then the intention of the conditions was that the rest of the requirements were to be demonstrated as part of that outline plan process, but there might be some edits we can make so that's more clear. It's a work in progress. Currently looking at drafting an additional condition around tangata whenua and other stakeholder engagement. So I think we've heard that that happens as a matter of practice, and that's the idea of the draft master plan, is that there will be, further a process on that, but building in a requirement that at the time of outline plan, demonstrating how that has been done, just to ensure that what we've heard today is translated into the conditions. Yeah, so there is already, as you know, the condition around working with Perirako on the earthworks. So just making that specific to earthworks and having that separate, broader condition, I think. Yeah. You did ask Mr. Collier to look at some wording around a condition. We haven't had any wording as yet, and as I understand it, this is
a condition that would seek to somehow provide some comfort to those businesses that they could continue to operate until such time as the land is needed for the active reserve. In my submission, that would not be an appropriate condition on the designation. The evidence is that there would be no issue for those businesses to continue until such time as the land is needed, but I'm not sure it's appropriate as a condition of a designation to include that. There is we've heard about the leaseback options and those discussions
Yes.
occurring in that separate acquisition process.
I think if I indicated that I was taking you in the wrong direction, what I was asking for is the method by which you might provide for that outcome. So, in terms of a consent that's lodged, in the way that it's treated by council or the commitments council might make that allowed that activity to continue. So, yes.
So not in the conditions.
No.
Sorry. Okay, I did.
Sorry.
Yeah. Yeah, just obviously you've heard from the requiring authority perspective that there would be no issue in terms of providing its written approval as holder of the designation. And then we can't, however, predict what the regulatory side with any application would do. But if the application had written approval from the requiring authority, the evidence from Mr. Hextall was that didn't imagine there would necessarily be a consenting issue in getting that through the other side of the table. So happy to delegate to Mr. Hextall to put some wording around that and circulate those to Mr. Danby to have a look
Thank
at
you
before
very
they come
much.
back. So unless the panel has any further questions, I think that's the notice of requirement.
Thank you. Are there any questions from the panel? Mr. Bing? Questions / statements? Oh, yes, the slice. No. We had a healthy choices lunch, and I think that's made us all a bit grumpy.
The problem you have as applicant is that we on the panel have a considerable track record and knowledge amongst us. It's a long time since I did much design work, but I have done it in the past. And I just have to say that I'm a little disappointed at identification of problems rather than capitalizing on opportunities. And I just throw that out to go into the mix when the negotiations take place. And I think that's probably all I should say.
Thank you. And just in terms of the childcare centre, I would note that confirming the notice of requirement wouldn't prevent an opportunity which may present itself through those discussions and negotiations outside of that was the result of that. And we have had evidence about how the requiring authority has been exploring other sites. So I think that those discussions can continue.
Thank you very much. Thank you. Well, if there's nothing further on that matter, we're going to adjourn that hearing and we'll provide feedback early next week about closure dates and directions, if any, and that resolves that matter. And now we come back to the
Plan Change 92. Yes, so I don't have any further reply from the two submitters on Plan Change 92 today, to the extent that Ms. Barabicino commented on Plan Change 92 and the corporate witness for Ryman. I think we indicated yesterday in the initial reply for Plan Change 92 that the council team has been giving some thought to the issue raised by the presentation from Perirako.
Yes.
What we would like to offer is just where those thoughts have got to at this point, and see if it's something the panel would like council to explore further. I would ask my colleague, Ms. Hawes, to speak to this issue.
Kia ora tātou. So in the lead up to this hearing and as the weeks progressed, the desire of the panel to hear the tangata whenua voice and recognise and provide for that in some way has been very clear. We heard on Monday the kōrero of Ms Shepherd, and that has really informed a lot of the discussion, particularly after the site visit. We've heard the questioning that the panel has put to submitters in terms of where they see the cultural landscape matters sitting in this process. And there's been a really clear direction to the council team to help the panel understand what can be achieved in this space. So just to reiterate Ms Stubbing's comments yesterday and the acknowledgement of council of the difficult position that the panel is in terms of this matter. So I'm just going to start by stating something which is kind of stating the obvious, but I'm going to state it anyway, which is that only Parirako can provide advice on the cultural landscapes and matters and values that are of importance to them. So with that in mind, the council team, they've come at this from the angle of looking at a policy response, looking at how these things have been treated through other policy provisions and definitions and responses, and really the options that have been considered and tested are just the start of this conversation. These are not solutions, it's just the start of something. So moving now to considering some of the options that we've discussed over the week. Just thinking a bit about cultural landscapes for a minute. What a cultural landscape has many different meanings. There are definitions in policy documents. Our Regional Coastal Environment Plan has a definition, but really it comes back to that there are different meanings for cultural landscapes, and Parirako are going to be the advisors of what that looks like. We agree with the submitters we've heard over the week who have advised that cultural landscapes can be qualifying matters. The difficulty in that is that outlined by Ms Stubbing earlier in the week, and that qualifying matters need to go through that very prescribed process in the Resource Management Act. They need to be identified in the Section 32 report. They need to be have the opportunity for affected landowners to address any concerns as part of the plan change process. We certainly know that there are other IPIs that have recognised cultural landscapes as part of that, IPI process, and they have followed that Section 32 and notification process. The council team then turned to considering some of the other concerns that we have heard from Parirako. Things like the ecological protection areas, the protection of gullies, the kaka migration pathways, mahinga kai and tuna, the waka egress, and putting those sorts of things to one side, also the Parirako capacity issues and their desire to engage in the process, but the capacity that holding them back. We think there is potential to seek to address, or at least have some of the interests recognised through the reserve and open space management planning, and in that space. There's certainly a fair volume of work that has been done in that space that could be drawn from and built upon in terms of the structure plan and the Plan Change 92 process, the Parirako Urban Design Guideline that was produced, the Gullies report. There's something to start with there. Thinking more about the concept of cultural reserve management planning, which we've seen used in other spaces. And what happens is this is developed and it feeds into the development of the reserve. It is a process by which cultural values such as resources of significance, customary practices, mahinga kai, tuna habitat, waka portage, it considers those matters of value to that hapu. And then it looks at how those can be recognised, for example, through place naming, carved po, signposting plaques, the appropriate types of native vegetation to be used. But really what that comes down to is that content needs to be driven by Pirirako. Council has turned their minds to this and has made a commitment to enabling this. At the moment, Council is in the stage of their 10-year plan development or long-term plan development, where this could be enabled, or looking for options within that process to provide some capacity for Pirirako to engage. So turning to think about how that would sit in terms of documents and policy. There's a possibility that a policy response could sit in the natural open space zoning of Plan Change 92. It's to be determined what that would look like, and there would be scope issues that would need to be worked through. There's another opportunity through the other work of council, and we've heard today as part of the separate but related NOR process, the reserve management planning, how that is undertaken with Pirirako at present. There is a review of the Kaimai Ward Reserve Management Plan, and that is set to commence in the next 12 months, within 12 months. And there's some real connections between that review of that plan and the wider kaka migration pathways that Ms. Shepherd described. There may be something to look at there. So where that leaves us is this is really a matter that's going to sit on that report back list. As I said at the start, these are options for discussion. The council team is very much in the panel's hands here and would very much welcome some comments and thoughts and direction about where we could take this, where you would see some appropriate direction. Kia ora.
Yeah, if you've got any thoughts.
I've got quite a few thoughts, but I just need you guys to, first of all, look to their hapu management plan, because it's got it all in there about what their, stacks of values set out in that plan about Omokoroa specifically and landscape. So it's a really good starting point to help guide how this relief might take shape, some ways to invest in Pirirako in terms of capacity and stuff like that. So that's all right now. It's the only sort of advice I can give, but start there.
Appreciate it, thank you.
I particularly want to acknowledge the fact that council is turning its mind to this issue and trying to think of ways to get through it, which we are all trying to do. If there was an easy answer, we'd have it already. So I think it's going to be helpful for us to have time to reflect, as Bennett's saying, and equally for council, so we can just keep it live and explore it over the next little while. And I guess it's ultimately going to result in some sort of direction back to council, so that we can get on with other things and have a focused response to that matter. So thank you very much for your efforts in that space.
Mr. Chairman, could I just seek your indulgence for a further copy?
Be hard to turn it down now, just after the last 5 days.
Well, it's now or never, I suspect. I just want to respond to the statement that you made that council, and I hope I'm not misquoting you here, council looks to Pirirako to drive this process. Did I hear you correctly?
Not so much drive, but provide, they are the only ones that can describe their relationships. So definitely, if they want to drive it, yes. But it's about providing them the capacity to have input into the process, how they see is appropriate, with support from council.
Yeah, well, thank you for that reassurance, but I think what I'd like to say is that from my considerable experience of interacting with tangata whenua and iwi and hapu groups, and in fact mediating between them, what I think is important is that anyone who's involved, whether it be the council or anybody else, should go to those groups to develop the issues or the problems and address them together. Whereas the tendency over the years, it's getting better, but the tendency over the years has been for non-tangata whenua groups, if you like, to go with solutions or even options. But from my experience, it's very important to go and talk about what are the issues, what are the problems, and work on them together. Do I make myself clear?
Yes, that's very much heard and acknowledged and understood.
Thank you.
Thank you. Is there anything further from the council team in relation to Plan Change 92?
No.
Right. With that in mind, then, we are going to adjourn the hearing for the same reasons that we've talked about over the last few days. It gives the panel time just to think about what directions might be useful and where the hearing goes from here. But I, for the record, want to acknowledge your team, Ms Stubbing, Ms Rutland and others, the governance team who have been absolutely fantastic, and the staff who make contributions to these processes. You are, you know, we are collectively in these processes making decisions that have an intergenerational outcome, and that it's not easy. And I really do welcome the contribution that you've made over this weekend and the time leading up to that. And also to say, of course, it's not over, we've got weeks to go yet. But thank you all for your time and energy and efforts over this week that we've had together. We've really appreciated it. Thank you. So I'm going to ask Ms Bennett to close with a karakia.
Me noi tātou, ka whakairia te tapu, ka wātia te ara, ture ki whakataha, ture ki whakataha, haungie, huie, tāi.